to mention matter. This is a testamentary PLA matter. I am mentioning for issuance of citation, my lord.
It is not in the list.
No, my lord.
May I have your kind leave to mention I'm praying for inclusion of two testamentary matters, non-contentious.
May I have my lord's kind leave to mention, my lord, a PLA matter 28 of 2024. My lord had allowed the amendments by an order dated 19th of December. My lord, I had communicated to the registrar within time. That was on 24th of December. But my lord, amendments couldn't be carried. My lord, we have been informed. Hence, my lord, I'm praying for extension of the order. Time to complete, my lord. Time to carry out this amendment, my lord.
What was the time mentioned?
My lord, 2 weeks in my prayer. But I have communicated within. Your lordship sees I have written on 24th of December. Order was dated 19th of December. But my lord, we have been told that the same has not been carried out. So my lord, I'm praying for an extension. Your lordship may kindly grants 2 weeks, my lord, further.
The matter is mentioned by the learned advocate appearing for the petitioner and submits that by an order dated 19th of December 2024, this court allowed the petitioner to amend the application within 2 weeks. Accordingly, the petitioner has communicated the order to the department, but the same has not been, but the amendment could not be carried out. Accordingly, counsel for the petitioner prays for extension of time to carry out the order dated 19th of December 2024 for amendment in the application. In view of the submission made by the counsel for the petitioner to complete the order dated 19th December 2024 by amending the PLA application.
PLA application.
PLA application is extended for a further period of 2 weeks from date.
Extremely grateful.
This order may be here 2 weeks.
Extremely grateful.
Lordship, I am mentioning CS 216 of 2024. In this matter, my lord, plaint was admitted during scrutiny by the department. It was found out that one of the annexure was mistakenly annexed, Annexure E. Lordship, I pray that the matter be kept and under to be mentioned on Monday, so that my lord, I may pray for leave to correct that annexure. It is just 1-page annexure.
May I be permitted to mention this matter, your lordship? It's a testamentary matter for inclusion in the list. I'm mentioning it for inclusion.
Praying for my lord Steve. My lord, the Lamatemetry lordship has concluded the hearing. Lord, we have also filed our notes. Lord, some 1 or 2 minute additional points, Lord, may have to be incorporated. Lord, may I file it not by Monday, Lord, additional. I'm grateful to Lordship. The defendant.
My lord, short pass over, my lord.
Judgment.
Apologize, your lordship.
No, it's not. Dismissed.
Injunction application.
Grateful one.
Grateful.
This has appeared at our instance, but I need not really trouble my lord. My lord had appointed a commissioner, and the date was 28th of February is the last date.
Yes.
And it was, but since November till now, my learned advocate and the commissioner, my lord, he could not get in touch with him. He was not well. But this morning, that's why we had mentioned it, so to change him, because he's not been keeping well, Mr. Sinha. But this morning I called Mr. Sinha. He's promised that he will do it. Because
he has informed that he's fixing the date tomorrow.
So I called him today. I said, "What are you doing? It's been a month already has gone by."
Lordship, I appear for the defendant in this matter, Zillion Projects. Lordship, it has come, I believe, at the instance of other side for changing the commissioner. Or what I was told that
No,
he will ask for change of the name of the commissioner.
No.
Because he's not carrying on the.
No, they are not asking for the change.
He's spoken. We couldn't get in touch with him.
That he will fix the date. He will continue with.
I think he's unwell for a considerable period of time.
Date
is
is
also not coming to court.
Yes, we know.
For some medical problem, I believe. That is what I'm being told.
My lord, 28th of February. I think my lord can extend it till 31st March. Otherwise, we've been simply wasting my lord's time today.
No, you do one thing. Let he start. What progress by 28? Let the court see. Then, if it is required, then we'll extend it.
Then your lordship need not pass any order today.
I am not passing any order. On 28th, before 28th, it is nothing been done, then I will see.
By popular
Your
request.
Formal, your lordship, a formal order, your lordship, will be
I
beneficial
think
for
my lord
everyone.
extend it to 21st, then at least, and make it peremptory or something.
Appearing for the
Since the matter has appeared, your lordship, formal order will benefit everyone.
appearing for the defendants. देख लेना क्या है. You are appearing for?
Your lordship, the defendant number 1, Zillion, HSCL,
I'm appearing for defendant number 1.
HSCL.
Number 2, my lord.
Defendant number 2, sorry. HS.
Counsel for the matter is listed as to be mentioned as the in terms of the order passed by this court dated 25th of November 2024, the commissioner is required to file report by 28th of February 2025. It is submitted by the learned counsel for the respective parties due to ill health of the learned commissioner. The commissioner could not continue with the could not proceeded with the commission, and now he has informed the learned advocates that he will proceed with the commission work. As such, the learned counsel for the respective parties prays for extension of time to file report by the learned commissioner. In view of the submission made by the counsel for the respective parties, time to file report by the learned commissioner is extended till 28th of March 2025.
I'm grateful. Grateful.
Grateful, your lordship. Extremely grateful.
My lord, this application in my instance, your lordship.
Yes.
Lordship. Oh, sorry, my lord. I'm really sorry. Well, item 3, my lord, the parties have settled. In fact, before 10:30, finally this terms of settlement was signed. My lord, this is a copy of the terms of settlement.
I'll be handing over.
I'm for the defendant, my lord. And as per the terms of settlement, my lord, I'm handing over a check of 10 lakh rupees, or pay order, a draft, demand draft of 10 lakh rupees to my learned friend. Well, that may be recorded, my lord. Well, the terms of settlement, my lord, defendant agrees to pay, page 3, 10 lakh rupees is the settlement amount, and my lord will see, my lord, Roman 3 is the particulars of the demand draft, and Roman 4, my lord, it is recorded that it will be handed over before your lordship, my lord, when the matter is taken up, which, my lord, I have done today. And my lord, order record. And my lord, only thing the my lord possibly records my lord's order that I have handed up the demand draft of 10 lakh rupees to him.
And money.
And my lord, only thing, my lord, the terms of settlement, since it was signed right now, it has not been
to my court office, sir.
Yes, it has not been stamp punched.
I am passing an order. You
Yes.
give to my court office.
Yes. Upon stamp punching, we'll give it to my lord's court office.
That may also pray for the refund of the court fee. It is not. It has just been presented before the learned master. That is all, Miller.
When the suit was filed?
Not in
March 2024 admitted, due granted, then all the things.
and only one presentation.
So appearing for the plaintiff, so appearing for the defendant. Full stop. It is submitted by the learned counsel for the respective parties. The dispute between the parties have been settled, and a terms of settlement has been entered between the parties. The plaintiff has filed the present suit, praying for recovery of an amount of rupees 10 lakhs.
30 lakhs. They claim
Principal amount of 30 lakhs.
30 lakhs along with interest at the rate of 15% per annum. Full stop. After the negotiation between the parties, the matter has been settled that defendant will pay rupees 10 lakhs being the full and final settlement, and the plaintiff has agreed to accept the said amount being the full and final settlement. Accordingly, the plaintiff, the learned advocate appearing on behalf of the plaintiff, has handed over.
Defendant has handed over.
Counsel for the learned counsel appearing for the defendant has handed over a demand draft of rupees 10 lakhs to the learned advocate appearing for the plaintiff, being number 309859, dated 3rd January
2025.
2025 of HDFC Bank, Stephen House Branch. Stephen House Branch and the learned counsel for the plaintiff accepted the same. Full stop. As the parties have settled their dispute and have entered into terms of settlement, and in terms of the settlement, the plaintiff has paid the total settlement amount of rupees, and defendant is sorry, the defendant has paid the total settlement of amount of rupees 10 lakhs to the plaintiff. Thus, the CS Com 765/2024 is disposed of. Full stop. The full stop. The terms of settlement filed by the parties be treated as part of the decree.
Leave to
No, that my lord will Stampach will take it back and within an hour's time, my lord.
And consequently, all interlocutory application also disposed of.
My lord, may the photocopy of the demand draft be taken on record.
Copy of the photocopy of the demand and be kept in the record.
May I take it back and my lord Stampach it and give it to my lord's office?
वापस दे दो. But you give it to
Yes, my lord.
Otherwise, I will not sign.
Within an hour, my lord will
Next.
Stampach.
Grateful.
My lord, my instance, my lord, I'm praying for leave to file the deficit court fees. Lordship, plaint was presented before your lordship. Lordship was granted the plaint. Admitted the plaint. After scrutiny has been completed, my lord, the department informed that there is a deficit court fees, your lordship. Leave be granted for the payment of the court fees.
Deposit court fee every 49,000.
Yes, your lordship.
961.
Yes, your lordship.
When you will pay?
Lordship, within 7 days, your lordship.
Full stop. The matter is listed as to be mentioned on the prayer made by the counsel for the plaintiff. Counsel for the plaintiff prays for a week time to pay the deposit court fee of rupees 49,961. Court fee of rupees 49,961. Accordingly, the plaintiff is granted leave to pay the deposit court fee within a week from date.
Once may indicate your lordship. Lordship, in the cost title, the defendant number is the Oriental Insurance Company. Lordship, the defendant is Oriental Insurance Company, your lordship. My lord, but in the cause list, your lordship, it was wrongly written like OL. Actually, your lordship, the direction we passed to department to.
And why to both branch?
Both branch, your lordship.
Both branch. It is fine from the cause list. In the cause title, the name of the defendant has been recorded as AL Insurance Company Limited and another instead of the Oriental Insurance Company Limited. Accordingly, the cause title in the cause list may be corrected as Panasian Impacts Private Limited versus the Oriental Insurance Company Limited instead of All Insurance Company Limited.
Grateful, my lord.
Lord, may I have your lordship's kind leave to present the plaint, my lord?
Yes.
Lord, but I'm for the plaintiff. Lord, this is a suit for recovery of money. My lord, I'm seeking today, my lord, for leave under clause 12 of the latest patent because, my lord, the defendant is situated outside the jurisdiction of this honorable court. But I have pleaded, my lord, that the purchase orders were issued, my lord, were received by the plaintiff within the jurisdiction. My lord, invoices were raised within the jurisdiction. There were balance confirmations which were issued by the respondent, which was by the defendant, which was received by the plaintiff within the jurisdiction. My lord. Part payments have also been, my lord, made within the jurisdiction of this honorable court because the plaintiff's office, my lord, is within the jurisdiction of this honorable court. My lord will kindly seize, my lord.
When the cause of action arose,
My lord,
when the last payment was made.
My lord, the last payment, my lord, was made in 2016.
Then?
But thereafter, my lord, there were balance confirmation letters which I have enclosed, my lord, in 2017 and in 2018, my lord, where they have admitted, my lord, that out of the total invoices for a sum of rupees 31 lakhs, 28 lakhs was due and outstanding, my lord. But those balance confirmation letters are also appearing at pages 118 to 12 of my plaint.
If you go by 2018 also, then where is
my lord, my lord, there are two aspects here, my lord, which I have also pleaded. My lord, the limitation period, if we calculate from 1st of April 2018, which is the date when the last acknowledgement was made, my lord, expires on 1st of April 2021. my lord, I have taken, my lord, the benefit of the Supreme Court, my lord, suo motu order, which was passed on, my lord, on 10th of January. My lord, from 1st of April 2020 till 1st of April 2021, my lord, a total period of 381 days I have calculated, which I'll be entitled to, my lord, seek benefit from 1st of March 2022, my lord, which also expires sometimes, my lord, on 14th of March 2023. My lord, this is one aspect. Still, I would be, my lord, barred by limitation. But what has happened in this case was the plaintiff, my lord, for the same cause of action against the defendant, was pursuing, my lord, a separate proceedings, my lord, before the National Company Law Tribunal, my lord, which I have pleaded, if your lordship sees the pleadings at paragraph 18 of the plaint. Lord, 18, 19, and 20. My lord, 18, we moved before the Honorable NCLT, my lord. That petition was dismissed, my lord. We preferred an appeal before the Honorable National Company Law Appellate Tribunal. That, my lord, against the impugned order, my lord, even that appeal was dismissed because of the fact that there are pre-existing disputes which can only be tried before the civil court, my lord. But we'll see the pleadings at paragraph 18, 19, and 20 of my plaint.
That's
My lord, under section 14, my lord, this entire period between 2019 and 20, my lord, I would have prayed, my lord, that this period will be excluded, because if your lordship sees section 14.1 and 14.2 of the Limitation Act, my lord, if I may just indicate.
So whether it will be applicable in the suit?
It will be applicable in the suit.
How? Limitation is applicable to the suit.
My lord, for this, because, my lord, in this matter, my lord, for the same cause of action, my lord, I was pursuing the remedy, my lord, before the NCLT for recovery of money. Because ultimately, my lord, even if the petition under NCLT would have been admitted, there would be a resolution plan, and ultimately under the resolution plan, whatever be the amount, I would have been entitled to, my lord. So for the same cause of action, if your lordship sees, my lord, in section 14.1, in computing the period of limitation for any suit, the time during which the plaintiff has been prosecuting with due diligence another civil proceedings, whether in a court of first instance or of appeal or revision against the defendant, shall be excluded, where the proceedings related to, my lord, this is important, the same matter in issue. Here the same matter was also, my lord, proceeded before the Honorable NCLT and is prosecuted in good faith, in which from the defects of jurisdiction or other cause of like nature is unable to entertain it. So ultimately, I suffered an order before the NCLT and the NCLAT, because the NCLAT and the NCLT both found in my petition under section 9 that there are pre-existing dispute which cannot be decided in a summary proceedings in an application under section 9 of the Insolvency and Bankruptcy Code. So, my lord, ultimately, my lord, the entire cause of action and my entire case have to be, my lord, established by way of a civil proceedings.
But why the NCLT has rejected your claim?
My lord, rejected, my lord, main fact was that there were pre-existing disputes. The defendant came and demonstrated that before the issuance of the demand notice, there were some defects in respect of the goods which were delivered to them, for which they have not made payments. And your lordship is aware, my lord, there are umpteen number of judgments which says that if there is a pre-existing disputes, in a dispute arising out of an operational debt, the NCLT will be denuded of its jurisdiction to decide such dispute. Lord, these pleadings are there, my lord. My prayers are at page 10 of my plaint, my lord.
Sensation for the plaintiff. Concept for the plaintiff. Praise for leave under clause 12 of the latest patent on the ground that part cause of on the ground that the plaintiff is within jurisdiction, but the defendants are outside the jurisdiction, but some cause of action arose, part cause of action arose within the jurisdiction of this court, and part cause of action arose outside the jurisdiction. Consider the submission made by the counsel for the plaintiff. Leave under clause 12 is granted. Plaintiff is admitted subject to scrutiny by the department.
I am deeply obliged.
Milord, item 8, 9, 10, I am for the plaintiff. Milord, this is at Credit Suisse My lord, Swiss bank fraud case, if your lordship recalls, Mr. Mitro was addressing my lord on the point of limitation.
I'm for certain of the defendants, my lord.
My lord, Mr. Mitro is on his way. My lord, he was in the middle of his arguments. I'm
Hmm.
only praying, my lord, if your lordship could just pass it over for a short while. Maybe perhaps after the 11:30 matter, my lord, it could be taken up. After the
11:30, there is a fixed matter.
So after, my lord, after that,
After the testament. Come tomorrow.
my lord,
Not today. Yes, next.
my lord, tomorrow is a Saturday. My lord.
Monday.
Next.
That day will be Monday. Which I appear on behalf of the petitioner. Your lordship kindly takes up your lordship's last order, wherein your lordship was pleased to direct them, the defendant, to deposit the amount of rupees 22 lakh before the registrar original side. I don't know if they've deposited it or not, because we have not been intimated.
No such amount by way of instrument has been received by the cash department.
Your lordship,
8th of January.
This is the N8 time. If your lordship will recall, your lordship have given them umpteen number of chances to first pay us on the ground of settlement. They have been dilly-dallying this matter. Lordship, thereafter, your lordship was of the view that since they have not given it to us to deposit it before the registrar, that also they have not complied with. Lordship, in these circumstances, I will be asking for prayer F for appointment of receiver over the assets of the respondent, so that the money can be paid to me.
What are the assets?
Lordship, those they will have. Lordship, they have 3 offices. They have instruction. Lordship, if your lordship kindly takes up the cost title, there are 3 addresses mentioned. If these are the offices that we are aware of. And Lordship, these are that we are aware of. They might have some certain other bank accounts or assets within the jurisdiction. So let a receiver be appointed so that he can ascertain, and if there is any asset within the jurisdiction, let it be utilized to pay my dues. So because on merits they have no defense, they have admitted that this sum is due and payable, and this is only the principal amount. Your lordship, my claim along with interest is around 44 lakhs.
Yes.
This has not been deposited. I am been told that he does not have the ability to pay this. Now, my lord, regarding this assets, I have to take instructions if they are still there or not. That I have to take instructions.
What?
Regarding the assets, if they are still there or not, I have to take instructions. I don't have instructions to that, but my instruction is that my client presently does not have the ability to pay this.
Lordship, such submissions calls for an appointment of a receiver, because in the meantime,
As
if they
my lord
dispose
deems
of
fit,
the
I cannot
assets,
stand in the way, but I do not know whether these properties are there or not. That I cannot ascertain. If my lord, once I can take instructions and come back tomorrow.
Lordship, I oppose this prayer of coming back, because the conduct of the
As my lord,
defendant, if your lordship
no,
is
I'm not.
pleased from this order,
I'm not standing in the way. I cannot stand in the way. If I can't deposit, I can't stand in the way. But I do not know whether these assets are there or
to
not.
let the receiver be appointed, he will ascertain if there are any assets or not.
So and so appearing for the plaintiff, so and so appearing for the defendant. By an order dated 23rd of December 2024, this court has directed the defendant to deposit an amount of rupees 22,59,740 before the registrar ordinal side of this court on or before 7th of January 2025. The registrar original side has submitted the report dated 9th of January 2025, stating the fact that the cash department stating that no such amount either by way of instrument no such amount by way of any instrument has been received by the cash department. Full stop. Counsel for the plaintiff submit that. In spite of a specific direction passed by this court, the defendant has not deposited the amount, and as such he pressed for appointment of receiver for take possession of the assets of the defendants so as to enable the plaintiff to realize the amount as directed by this court. Please, counsel for the defendant submit that the defendants are not in a position to deposit the amount. Defendant is sole defendant. Defendant is not in a position to deposit the amount as directed by this court. And he submit that he will take appropriate instructions with regard to the property and assets of the defendant. Full stop. Considering the above, considering the submission made by the counsel for the respective parties, this court is of the view, before passing an order for appointment of receiver, it would be appropriate that the defendant should be given an opportunity to file the affidavit of assets, declaring their assets before this court within a week from date. Let such affidavit be filed, such affidavit of asset be filed by the defendant on or before. Today क्या है? आज कितनी तारीख है? 10 है. On or before 20th January 2025. List the matter on 21st of January.
One indulgence in the meantime, they should not.
Let they come.
So in the case if they alienate, your lordship, there was already an injunction on the bank accounts.
Correct.
If your lordship, if your lordship extends that ad interim order, and if your lordship,
it is directed that till the affidavit of asset is filed, the defendants are restrained from dealing with any of the property.
Grateful, your lordship.
Yes.
Lordship, with the deepest of regret, my lord, item 8, 9, and 10, your lordship had taken as directed to keep it on Monday, my lord. May it be on Tuesday. My other side is here, my lord.
No objection,
There is some difficulty of Mr. Mitro, my lord. He might not be there.
8, 9, and 10.
8, 9, and 10.
Suffering for the plaintiff, suffering for the defendant, as per the prayer made by the counsel for the plaintiff. Plaintiff, let the matter appear on
Tuesday,
14th
14th.
January.
I'm
14th
grateful,
January.
your lordship. Grateful.
Grateful.
Very good. Yes.
Two applications, my lord, of the plaintiff have come up, GA1 and GA3.
I am for the respondent.
The division bench, my lord, the appeal court has, my lord,
Fix the matter, your lordship, in next week.
called for a report from a chartered accountant. That report has been, my lord, day before yesterday.
Which one?
Direct, my lord, item 12.
GA1, your lordship, the order was passed, your lordship, in respect of security on the basis of Rahul Shah. We preferred an appeal, your lordship, and the honorable court, your lordship, directed for valuation of the shares in connection with one company. Now the valuation report has come. Yesterday, your lordship, the direction was passed to give the copy of the report and the matter to be fixed next week, your lordship. Any day, your lordship.
My lord, I am filing my reply in GA3. Lordship may take that on record.
And
So far as
my
GA1 is
your
concerned,
Want to deal with it.
my lord, since GA1, my lord, no directions has been, my lord, issued yet. Kindly, my lord, permits, my lord, the parties to exchange affidavits. My lord,
Lordship, Mr.
in GA1.
Bachawat is leading me, your lordship.
But on that note, that order is under appeal. No modification should be made to that order.
I am not passing any order.
My lord, I am not seeking modification of
Not
that
modification.
order. I
Let
am
the
today
appeal
seeking.
is disposed of by this GA1 will dispose of by one order of
My
the
lord,
appeal.
the difficulty is, my lord, it would only delay GA1. Whatever is the outcome, my lord, they have filed written statement.
It cannot be one of the grounds of challenge is
Okay,
that.
let it come. Let it.
My lord, the interim order is expiring on 14th, my lord, subject to outcome of the appeal that may be extended.
So suffering for the plaintiff, so suffering for the defendant. Full stop. Counsel for the respective parties submit that appeal is pending before the appellate court. Counsel for the plaintiff has filed affidavit in reply
in GA3
in connection with GA3 of 2024. Let the same be kept with the record.
Lord, in that reply, he has disclosed a new document. Could I deal with that with the one, only that document? Give me leave to deal with that.
Counsel for the defendant submit that the plaintiff has relied upon some document in the reply. Accordingly, intend to file rejoinder to the said reply. Accordingly, the defendants are at liberty to file rejoinder to the affidavit and reply filed by the plaintiff by disclosing the document.
The interim order.
Counsel for the plaintiff submit that the interim order passed earlier is going to be expired on 14th of January 2025. Accordingly, the interim order granted earlier is extended 2025. Let the matter appear on. Let the matter appear on 7th February 2025. The interim order granted earlier is extended till 11th of February 2025 until further order, whichever is earlier.
But instead of 7th, may I prefer 10th, my lord? Instead
10th and 14th.
Grateful, my lord.
Extended till 10th. List matter on 10th. Extended till 14th.
Grateful, my lord. Lord, I beg to appear on behalf of the petitioner.
Yes.
My lord, my suit for recovery of price of goods sold and delivered. My lord, my suit for recovery of price of goods sold and delivered. My lord, we have taken out an application, my lord, for judgment upon admission and other reliefs, my
Writ
lord.
of summons served.
My lord, writ of summons have been served.
Served.
My lord, it has been lodged, I am told. My lord, it has been lodged. My lord, your lordship had show cause the defendant. My lord, we had served them and we had filed the affidavit of service, my lord, on the last occasion. My lord, they have received.
How many address? 3 address?
Yes, my lord. Lord, they have been, my lord, they have been served at the Howrah address, my lord. They are sent to all 3 addresses.
Item delivered. What about the 2 return? Door closed. 1 is delivered, 2 is door closed. Return to sender.
Yes.
Yes. So what you want now?
Yes.
But writ of summons when not served.
My lord, it has been lodged, my lord.
Then how the judgment upon admission will be taken at this stage? Let the writ of summons be served.
My lord, it has been lodged. It has not been served, my lord. I am instructed.
Let it be served.
My lord, interim measures, my lord. Lord, writ of summons, my lord, they will file written statement.
Correct, but it is a judgment upon admission.
Yes,
Interim order, no.
My lord, I am not praying for
Then judgment upon admission. Let the writ of summons be served them. If they appear, then I will take.
My lord, subject to what falls from your lordship, my lord, order 12, rule 6, my lord, at any stage, my lord.
That's correct. That's correct. Order 12 rule, let the writ of summons be served.
Very well. My lord, I must indicate one thing. My lord, I was placing 2 documents before your lordship on the last occasion. Page number 18 and 19. My lord, these are, my lord, schedules showing the invoices raised and my lord, the payments received. Now, since, my lord, we had placed these 2 documents, my lord, the balance, my lord, was not totaling up to my claim, which is why your lordship had said that we should come back with a clarification. My lord, what has happened, I have seen. If your lordship kindly takes page 7, para 13. My lord, this is the sum, my lord, that we have claimed as at 7th April 2022. But my lord, we have ascertained, my lord, the differential is not coming to this sum. This is because, my lord, debit note of rupees 24,000, my lord, has not been shown in the schedule. My lord, that is a, my lord, mistake. So this schedule A is not correct.
Correct. So,
My lord, we'll have to take steps.
take steps.
Very good. I just indicated it to your lordship.
Since suffering for the plaintiff. The plaintiff has filed the present application being GA Com 1 of 2024, praying for judgment upon admission. Police. Counsel for the plaintiff has served the notice upon the defendant through speed post in 3 addresses. Out of 3 addresses, in 1 address, the notice has been duly served upon the defendant and filed affidavit of service, but in spite of receipt of the notice, none appears on behalf of the defendant. Police. Counsel for the plaintiff submitted. The plaintiff also lodged the writ of summons. Police. In view of the above, this court is of the view this application can be taken up for hearing after receipt of the report regarding the receipt of writ of summons. Let the matter appear on.
Lord grants me 4 weeks, my lord, I shall take steps.
On 14th of February 2025.
My lord, 1 more week, my lord, permits, so that we can come back
18,
after it.
18th February.
Grateful.
21st February.
Grateful, man. Grateful.
Lordship, item number 14, I appear on behalf of the petitioner. And the last occasion, your lordship had permitted the petitioner to cause substituted service upon the defendant number 2, the respondent. Lordship, and I have prepared an affidavit of service. With the affidavit of service, only thing, lordship, I should indicate, lordship had permitted the petitioner to publish the notice in 2 newspapers, Statesman and Sunlight. Lordship, due to some miscommunication, the petitioner has published in Statesman, but apart from Statesman in 2 other newspapers, but not in Sunlight. If your lordship pleases, then I shall again publish it in Sunlight. This I thought I should indicate.
Indian Express.
Indian Express, and there's
Statesman.
another Bengali daily. Statesman, yes, lordship.
Statesman, Indian Express, and Bengali newspaper.
Yes, Bengali
Ek din.
newspaper at Din.
When it was served, when it was published,
Statesman was published
6th January.
6th of January, but if your lordship sees the Indian Express, it was published on January 1st, and Actin also on January 1st.
So what is the date given in that? Any date was given?
Yes, lordship.
What is the date?
Exact.
Where is the original? That is the original paper.
No, lordship.
You have to annex the original here.
Lordship, if your lordship is seeing Statesman,
I can't read this.
it has to be translated. Yes, yes. No, it is in English. It is in English. Lordship, if your lordship is taking up the Indian Express, then lordship, the second change, just below change of name is notice in the High Court at Calcutta Commercial Division.
18 January.
Yes. And
8th January.
just above Schedule A, your lordship will find the date.
8th January.
Lordship, I appear for the respondent number 1.
Yeah,
Lord, the affected party, the bank. Now, bank has been injuncted from taking measures under the Surface Act. We are taking the measures under the Surface Act, and an ad interim order of injunction with clause 12A leave has been granted by this court. And my lord, we have been injuncted from proceeding further. So, my lord, I was strongly opposing for the extension of the interim order. Lord, no directions have been given to file objection affidavits in this matter.
File their objection, lordship.
My lord, they have claimed that.
Purchased this property way back in 2019.
Yes, how? That has to be seen.
By a deed
It
of,
cannot be. The mortgage is with me.
Yes, lordship, but that has to be decided. If they choose not to file their opposition, then lordship can hear.
Directions have been given.
If they choose to file their opposition, then lordship would kindly extend the interim order.
You got the interim order in vacation bench.
Lordship.
Yes, and your
And
lordship
ad
has
interim without any service.
And your lordship has extended that. to
Vacation
the-
bench, normally we know that why without service, normally it is not accepted. And 12-way leave was granted, that too, my lord, also, my lord, in the vacation bench.
Okay, you are not filing any application
My
for
lord,
vacating?
Lordship, I have. My lord, we are in the process. My lord, written statement has already been filed. My lord, we are in the process
Written
of
statement file?
lordship. Because that
You
was a
affidavit file, no?
no, my lord, that direction has not been
Filing a
lordship. I
vacating
will
application?
lordship.
Written statement yet.
We shall serve it because it was within time.
When you receive the return summons?
My lord, I have received the return summons of 9th of December. I have entered appearance. I have intimated to my learned friend.
Okay.
And my lord, I have also filed the written statement, my lord, 2 days, 1 day or 2 days back, my lord.
So and so appearing for the plaintiff, so and so appearing for the defendant number 1. Full stop. Counsel for the plaintiff has filed affidavit of service showing that the paper publication for the purpose of service of notice upon the defendant number 2 was published in the English daily newspaper, The Statement and The Statesman on 6th of January 2025, Indian Express on 1st of January 2025, and Bangla newspaper Egdin on 1st of January 2025. By mentioning the date of fixing the matter on 8th of January 2020. Counsel for the plaintiff submit that in spite of let the affidavit of service be kept in the record. Well, in spite of service of notice, none appears on behalf of the defendant number 2. What about the other?
Others were served, they have received, and lordship have already.
None appears on
filed
behalf of the
affidavit of
defendants.
service for the last
Defendant number 2, 3, and 4. 2, 3, and 4. Full stop. Counsel for the defendant number 1 bank submit that the plaintiffs have obtained interim order and are enjoying the interim order, and he has objected for extension of the interim order. Full stop. Considering the submission made by the counsel for the respective parties, though this court has already granted an interim order, which is extending,
10th of
which is going to be expired today, and thus let the interim order be extended till 31st of January 2025 or until further order. Full stop. The defendant number 1 is at liberty to file affidavit in opposition within 2 weeks from a reply, if any, there to be filed within a week thereafter. List the matter on 31st of January 2025.
Lordship,
The plaintiff is directed to obtain report from the department whether the defendant number 2, 3, and 4 have either entered appearance or filed written statement or not on the by the next date fix.
Lordship, the defendant number 1 says that he has already filed a written statement, but lordship would kindly record we have not been served a copy of the. We have not received.
Hey, CS hai? Yes, it is not. CS is not here. Next.
15, Lordship, I appear for the defendant.
Yes, my lord, I appear for
An
the plaintiff.
extension of time for filing my affidavit in opposition to their application, Lordship.
My lordship would recall, my lord, my lord, the account was declared as an NPA, and my arguments.
No appeal.
No appeal.
Nothing yet,
My
Lordship.
learned friend has accepted your lordship's order, my lord.
No, not to be recorded that I have accepted. Nothing yet,
Yes.
Lordship.
You want to file
Lordship, 3 weeks time I'm praying for. The
My lord, the ad
case
interim order
officer
that was
not
passed by your
available
lordship on the last occasion after contested hearing, my lord, that may be extended.
Yes.
My lord, the order dated December 16, 2024. I have a copy.
Only one defendant?
Yes, my lord, only one defendant. State Bank of India.
So and so appearing for the plaintiffs. And so appearing for the defendant bank. Counsel for the defendant bank prays for extension of time to file. Praying for extension of time to file affidavit in opposition. Let affidavit in opposition filed within 3 weeks, reply if any there to be filed within a week.
Fortnight, my lord.
Within 2 weeks thereafter. Full stop. This is the matter. 3 weeks, 2 weeks, 5 weeks, na? That's the matter on 17th of February 2025. The interim order granted earlier, which is going to be expired on 11th of January 2025, is extended till 19th till 21st of February 2025 or until further order, whichever is.
MD.
Great.
Your Lordship, we were supposed to, we were supposed to file this by 7th, as we are a couple of days late. So a rejoinder to our, I'm giving a copy to the other side.
Yes. Just been served with a copy, my lord. I've just been served with a copy, but may I indicate, my lord, in this matter, the examination in chief is ongoing. My lord, this is an application taken out with regard to the maintainability of the suit by filing an Order 7 Rule 11, challenging on the ground of limitation. My lord, limitation is a mixed question of fact and law. It has come up at the stage when the trial has
That
already
will taken
commenced.
up at the time of hearing. What you
My lord, at the time of hearing, that is my
But
prayer that let this matter be taken up at the time of hearing.
No, when the suit is fixed.
Well, the suit is fixed on 24th of February.
Yes, so
sir.
I am hearing this application prior to that.
Yes, Your Lordship. That's
Because, my lord, now that it is already in the stage of trial, I was only praying if the matter can be taken as a main issue in the suit and can be heard
Main
altogether.
issue in the suit with regard to
My lord,
limitation.
Yes, Your Lordship,
my
it's
lord.
only.
This is also with regard to limitation,
Lordship,
which
may
is
I-
why I'm saying
Yes,
this.
indeed. There's a question of only limitation. My questioning is only on limitation, but this is nothing to do with facts anymore here. It's a very interesting thing to say. It's a mixed question of fact and law and all these things. We have all done it in college and when we wrote our examinations and all that. Very interesting thing to say. But here it's in relation to interpretation of the judgment with relation to COVID. Our understanding with regard to the judgment is that any matter whose limitation ended during that period would get 90 days after that period is over to file whatever they had to file. Their understanding of this, that is, that no, that entire period which has been lost.
Subsequent judgment you had. Justice Chandrachud judgment you had.
The judgment, with COVID judgment is there. They have an
subsequent
explaining the previous judgment.
Extending the period, the limiters start from that.
But Your Lordship, we will come to that. But I will show the judgment.
And my judgment is also there, referring that.
Very well. I will
So
take Your Lordship.
So in that case, so what I prepare, this is only the limitation.
Only limitation.
Correct?
Only limitation.
And that an interpretation of the Supreme Court.
Very well. Yes.
Correct. And you are cross-examining the witness.
Yes.
It's in chief.
Chief, as of now, is in chief.
You will,
Yes.
You will cross-examine.
Yes.
So let this matter be tagged with the.
Very well. I don't mind. I'm just raise the issue. It can be tagged along whenever it is taken up.
So suffering for the plaintiff. So suffering for the defendant. The plaintiff has filed affidavit in reply.
And Your Lordship, you have given a copy.
No, defendant has filed affidavit in reply in connection with. Who has filed the affidavit in reply?
My lord, my learned friend has filed the defendant.
Defendant has filed affidavit in reply in connection with GA Com 2 of 2024. After serving the copy to the learned counsel for the plaintiff, let the same be kept with the record. The defendant has filed the present application being GA Com 2 of 2024, praying for rejection of the plaint on the ground of limitation. It is fine from the record, the suit is at the stage of trial and witness of the plaintiff is going on. Thus, this application be decided along with the main suit.
Your Lordship, there is
that the application filed by the defendant being GA Com 2 of 2024 be decided along with the main suit.
Your Lordship, my learned friend reminds me there was a direction on us to pay some costs of 25,000 rupees.
In respect of GA1.
GA1. I don't know. I don't have instruction because I have not met. My solicitor is not here. I will, if it is not, I will make sure we'll.
Because it's a GA.
My lord, I have no issue.
Capable. List the matter. On when it is fixed?
24th of February.
24th of February 2024, along with CS Com 525 of 2024.
Lordship, I appear for the defendant number 1.
Lordship, two applications appear on the list today, Lordship. May it please your Lordship to hear me through the virtual mode today.
What is the
I am
application?
I am the pro forma defendant, Lordship, here, Hitachi Energy. So two applications, both are my applications. GA2 Lordship is an application for extension of time to file my written statement. Lordship had granted me liberty on 1 day prior to the Christmas vacation to lodge my written statement in the department. I have done that. The application Lordship had said must be filed right after reopening. I have done that. That application has now come up before your Lordship. I have already filed my written statement. There's a delay of around 100. I mean, I have filed it within the 120-day period, I think around the 103-day mark, Lordship. I am only a pro forma defendant, so I am saying Lordship would kindly consider not imposing any costs for the delay, Lordship.
Yes. And what is the other?
The other one, Lordship, is GA3, which is my application, Lordship, under Order 1 Rule 10(2) for striking out of Hitachi, that is my client, as a party, because according to me in the plaint, there is no explanation as to why I am a proper and necessary party to be before your Lordship in this suit. So if my learned friend consents, then Lordship can pass an order on that, or if my learned friend wants to file an affidavit in opposition, that he may submit.
Well, if I may be permitted to respond, my lord, there are two GAs. Insofar as GA2 is concerned, but ideally I would not like to oppose this application. But in paragraph 5, the explanation is not sufficient. Which I just wanted to indicate to your lordship, my lord. There is absolutely no explanation at all. And even if I consider like a line of explanation which is provided, it is not sufficient, it is not correct. And I would deny the statements which are there in paragraph 5, but I leave it to the discretion of this honorable court.
Yes.
So far as GA3 is concerned, my lord, I'll file an affidavit in reply, because the presence of the defendant number 2 is very important in so far as adjudication of this case is concerned.
What about the other defendants?
Lordship, I apply for the defendant number 1. No GA has been served upon us as yet.
Oh, that is upon me. Yes. You file the written statement?
Not yet, Lordship.
They have not filed.
They have not filed, but the 120th day expires on 15th of January, so they have time till 15th of January.
How many different
There are two defendants, my lord. and
One
this-
is performer, one is main. So.
But may I just also indicate one thing, my lord, on the last order, which is recorded on 7th of January, my lord, it is perhaps wrongly recorded that the plaintiffs have prayed for time, my lord. In fact, it was the defendants who had prayed for time, my lord. So if that, my lord, portion can be, my lord, modified, my lord.
I think defendant number 1 had prayed for some time to file an application. They had challenged. I was present before your lordship on that day. They have challenged the jurisdiction of the court.
Sense appearing for the plaintiff, sense appearing for the defendant number 1, and sense appearing for the pro forma defendant. Pro forma defendant has filed 2 applications, being GA2 of 2025, praying for extension of time to file return statement. GA3 of 2025, praying for deletion of name of the pro forma defendant from the suit. Counsel for the defendant number 2, pro forma defendant number 2 submits that the writ of summons was served upon the defendant number 2. When it was served?
September 10, lordship.
On 10th of September 2024. 10th of September 2024. On receipt of the the counsel for the defendant number 2 submits that the office of the pro forma defendant number 2 is located in a different state, and consequently it was taken time to appoint the local representative as Kolkata to take appropriate steps to engage the lawyer and to take appropriate instruction, and accordingly for the said purpose the defendant number 2 could not file the written statement within the prescribed period of 30 days, but has filed the written statement on
24th December, Lordship.
21st of December
24th December, Lordship. 24th.
December 2024, with the liberty of this court, subject to acceptance of the same. Counsel for the defendant number 2 submit that as the defendant number 2 has filed the written statement. No, and though the defendant number 2 has not filed the written statement within the prescribed period of 30 days, but has filed the written statement within the period of 120 days, and as such he prays for acceptance of the written statement. Per contra, learned advocate appearing for the plaintiff raised objection and submitted that the defendant number 2 has not shown any cause as to why the defendant number 2 has not filed the written statement within the period of 30 days. He submitted that the reason as shown in paragraph 5 of the application is not a sufficient ground to condone the delay and extend the time to file written statement after the period of 30 days. Third, the learned counsel for the respective parties perused the materials on record. This court find that the writ of summons was served upon the defendant number 2 on the
September 10, Lordship.
10th of September 2024. Full stop. But the defendant has not filed the written statement within a period of 30 days. Admittedly, the defendant number 2 has filed the written statement on 24th of December 2025. That is within the outer period of 120 days. Considering full stop. This court will also find that the defendant office is outside the jurisdiction of this court and have taken appropriate steps to appoint the advocate to file the written statement. According, this court is satisfied with regard to the cost shown by the defendant number 2. Considering the above, this court find that one opportunity should be given to the defendant number 2 to file the written statement. Accordingly, the written statement filed by the defendant number 2 on 24th of December 2024 is accepted subject to payment of cost of rupees 5,000 in the State Legal Service Authority within a week from date. Full stop. The department is directed to accept the written statement subject to scrutiny. Full stop. The defendant number 2 is directed to serve the copy of the written statement to the plaintiff in course of the day. There is no counterclaim.
There is no counterclaim on my behalf, Lordship. Just one thing, Lordship has mentioned 30 days, but in my writ of summons, it was mentioned 35 days, that particular writ of summons that I.
But we have to go by the act, not by the.
Yes, Lordship.
Yeah, okay. GA number so disposed of. Full stop. As regard GA3 of 2025, the counsel for the plaintiff prays for time to file affidavit in opposition. Let affidavit in opposition filed within 2 weeks. Reply, if any, there to be filed within a week thereafter. List the matter on 11th of February 2020.
Would Lordship kindly consider a reduction in the costs, considering I am a pro forma defendant, Lordship?
5 is the minimum.
But if the last order, my lord, that
Achha.
paragraph
Counsel
can
for
be.
the plaintiff has brought to the notice of this court to the order dated 7th of January 2025, wherein in fifth paragraph, it is mentioned that the counsel for the plaintiff prays for time, but instead of the plaintiff, the defendant number 1 prays for time. Accordingly, in the order dated 7th January 2025 may be corrected in paragraph 5 that the instead of counsel for the plaintiff, it shall be read as counsel for the defendant number 1.
I'm great.
Much obliged, Lordship. Much obliged.
Next.
All right.
आगे देखो यहाँ तो पंच कहाँ है पंचिंग नहीं हुआ वेयर इट इज affirmation नंबर नहीं डालते क्या पंचिंग में नंबर नहीं डालते फिर कैसे कैलकुलेट करते अभी नंबर नहीं डालेगा तो आप लोग ऑडिट नहीं होता तो ये पैसा कहाँ से आएगा व्हाट इज So you are mentioning this will go to the audit will come. It is going on in the Calcutta. Yes. Call karo.
Item 18,
18.
I am for the plaintiff, my suit for eviction and occupational charges against the respondent tenant. Before your lordships, there are 4 pending applications. GA1, which is my application for payment of occupational charges during the pendency of the suit. GA5 is the defendant's application. GA4. Yes, GA4 is their application, my lord, under section 10 of the CPC, saying that, my lord, their
What is the GA1?
GA1 is for payment of occupational charges.
Okay.
The tenancy was terminated by notice dated August 2019. From September onwards, no payment has been made. 64 months have passed, not a penny has been paid. Last
And
paid
what
rent.
about the 4?
GA4 is their application under section 10, saying that the stay of the suit,
And
because 5 is my application for summary judgment. And GA6 now filed in December 2024 by the respondent or defendant, my lord, praying that it's a demurrer, saying that the suit should be transferred to the regular ordinary division of this honorable court. My lord, the background, if I may indicate,
No,
from
who is for the
September,
defendant?
Mr. Aurik Banerjee was appearing for the defendant. My lord, even on the last occasion, my lord, if your lordships has the order dated December 16th, sorry, my lord, December 9th, the time was prayed for by the defendant. December 16th, their GA6 came up for the first time. Now, my lord, this is a demurrer filed by the defendant on the ground that subsequent order. My lord, this, my lord, the background of this litigation is that I filed this suit in the ordinary division first. Thereafter, they filed.
Okay, and the other side is not here. What can be done?
My lord, the difficulty is that, my lord, my property is not generating any money from August 2019.
Okay,
64 months. Very well.
After this matter,
Very
I will
well.
take the matter.
Very well.
Yes, next. Call the fast. Item number? Yes.
Mr. Tanuj Gupta, my lord, appearing for the applicant in this matter.
For the
My lord.
plaintiff.
He is, my lord, down with high fever, my lord. May I pray for my lord?
I don't
He
stand in
has
the way,
been
my lord.
regularly appearing, my lord.
They've complied with my lord's order. My lord will kindly just direct. My lord has the order of 20th December 2024. My lord, this is that matter, my lord, after an injunction.
Yes, yes.
My lord, 20th December 2024, it's been recorded that the sums, my lord, which were encashed in their favor have been kept
That
in a
is
separate
common.
account.
That
My lord
is
will kindly continue that direction so
there.
that the
That's no problem.
my lord then will adjourn it. I don't stand up.
As per the prayer made by the counsel for the defendant number 2.
Yes, my lord.
Defendant number 2, case is adjourned. Let the matter appear on 29 January.
Subject to my lord's convenience, can it be on 7th of February, my lord?
7th February.
My lord, 4th February, the matter is as it is coming up.
Already
Yes, yes, 4th February.
4th February. 4th February is holiday. Yes. 4th February is holiday. You will not
No,
celebrate
not
the
4th.
Saraswati Puja.
May I say?
No, it was sorry, my lord. The interim order was extended till 4th February, but it was listed also on 4th February. If my lord
Okay, I
has
am
it.
fixing on 7th.
Yes, my lord. No.
7th. Next.
Grateful.
रेगुलर वही रेगुलर में फास्ट वर्क जो है ना 18 नंबर कौन है
I am led by Mr. Krishnaraj Thakkar, my lord. I believe he is appearing virtually. Very well, my lord. I am here, my lord, for the plaintiff. And my lord, my application GA1, which is for payment of occupational charges, because as I indicated, my lord, from September 2019, the defendant has been occupying the premises without payment of any rent. The last paid rent was 1,09,000. This application, my lord, was argued before your lordships in September 2024. If your lordships has the order dated 10th September 2024.
That's correct. Mr. Thakkar has already argued the matter. Defendant has already argued the matter in part.
Yes.
So where is the defendant?
Thereafter, they have filed a GA6.
GA6 will be taken subsequent. No, it is
Yes.
going on.
Yes,
But where is the defendant?
They are, as your lordships can understand, they are avoiding hearing so that they can avoid payment of any occupational charges. So my prayer is, if your lordships gives a short date, or my lord takes up the application and
What is
hears
the
it out.
occupational charges?
1,09,000 was the last paid rent.
Last paid rent is?
1,09,000 250 rupees. My lord, in GA1
From which month?
from September 2019. The petition.
When you filed the suit?
But this suit was originally filed in the ordinary division and thereafter filed in this division on 1st of July 2021. The ordinary division, the earlier suit was dismissed by order dated 15th of February 2021. Thereafter, filed this suit on 1st of July 2021. And my lord, GA1 if your lordships takes.
Okay, I am fixing next week. If they will not appear, then I will proceed with the matter.
Very good.
Nobody
Grateful.
there.
Grateful, my lord.
So and so appearing for the plaintiff. So and so appearing for none appears on behalf of the defendant. Full stop. Counsel for the plaintiff has filed an application being GA1 of 2021, praying for a direction upon the defendant for depositing the occupational charges. Full stop. As none appears on behalf of the defendant, accordingly, for the interest of justice, the case adjourned. Let the matter appear on 21st of January 2025 under the same heading. It is made clear that on the date fixed, if the defendant failed to appear, the application necessary order will be passed.
GA1, your lordship. Grateful.
Next.
Right, number 19 is it involves the two applications.
Yes.
I am for the defendant. My demeanor application lordship is hearing. I am in reply. And there is another prior application for judgment upon admission that the plaintiff had moved on the last occasion. Lordship's view was that Lordship will hear both the applications together. I will also respond to that. On the last occasion when matter was taken up, I indicated that
had
that
completed
Lordship
our
does not.
confusion, my lord, because my lord, here the name, the issue which they had taken was the name, that name was different. Registered, my lord, mortgage deed, the name was different. Therefore, my lord, that is after taking payment and
reply
after acknowledgement, my lord, they
on
have
the last occasion when Lordship matter was called, my lord, I indicated that Lordship did not have a affirmed copy of the affidavit in opposition to their application to the judgment upon admission. The Lordship called for record from the department. But I am not aware whether the department had found that affidavit from its record. Most probably not, because the same effort was once made before the when the matter was before the learned with the other bench, my lord. So it's a Lordship is holding a Xerox copy from my brief.
Which affidavit?
AO to the judgment upon admission.
That is to
আমার জুনিয়ররা ছিল আগের দিন সামনেই ওটা হয়েছে না নেই তো ওটাই তো আগের দিনও অরিন্দম মুখার্জির সামনে হলো না
No affidavit is filed.
Yes, it was filed, but the original affidavit is not being found from the record. That's
why there is no affidavit is in the department.
I know that I sought for leave, my lord, to reaffirm the same affidavit which I had filed. The Lordship is holding my Xerox photocopy. I'll reaffirm, otherwise, my lord, the record will be incorrect in respect of that application. I sought for that leave last occasion. Lordship said Lordship will first call for a record from the department and then give me this leave if required.
So that's why that you're not filed. So why how the reaffirm?
But I have filed it. It's recorded in the order, but the original affirmed affidavit is not in record. My copy is
not in the department also.
But that is absolutely correct. I most probably changed brief for us. The asked for advocates most probably will not file it in court when the matter was in a different court at that point of time, and probably misplaced file will not be records court. I do not know how, because it is how we filed. I have a copy which is affirmed, but the original copy is not traceable from the records.
Correct.
So I will reaffirm the same affidavit which I had filed, and I can file it again.
Because in the ledger also it is not mentioning.
Unless it is filed in the department, it won't be mentioned in the ledger.
Correct.
But then Lordship kindly gives me to file an affidavit to. I will file the same affidavit, the same stand I maintain. But I can't change my stand. So affidavit I once filed, I have to maintain it. So
yes.
The same affidavit I will reaffirm and file.
But that letter says they have filed it.
Yes, I am also
That's
saying.
correct. That's why this court has called for report. But in the report it says that no affidavit as per the ledger, no affidavit is filed.
Read out. Please find enclosed here with a copy of the affidavit in opposition filed on behalf of a client.
It might be filed, submitted, affirmed, given the copy to you. It is not filed in the department.
That may
kept in
also
the-
happen. I was not there. I
Every
mean,
time it is happening when the court is searching the affidavit, then it is coming from the lawyer's brief.
Right. But here, Miller, it is not in our brief. We have checked our record. It's a change brief. We do not know what happened on that at that point of time. So kindly give me the leave to file an affidavit in opposition
Of the GA1?
of GA Miller
3.
GA3.
GA3.
So and so appearing for the plaintiff, so and so appearing for the defendant. Full stop. Counsel for the defendant submit that the defendant has affirmed the affidavit in opposition in connection with GA3 of 2024 and also served the copy to the learned counsel for the plaintiff. But the same is not on record. Accordingly, this court has called for the report from the registrar of this or registrar original site and on 20th full stop on 20 December 2024, the registrar original site has submitted the report wherein it reveals that as per the ledger maintained by the department does not show the affidavit in opposition is filed by the defendant in the department. Full stop. Counsel for the full stop. Counsel for the defendant, considering the report filed by the department, press for time to file affidavit, a fresh affidavit in opposition. That affidavit in opposition filed within a
Yes. I've just
within a
reaffirmed
week,
this.
reply if any. You have filed the reply?
Yes, reply is also they've
Already filed.
yes
Everything
to
filed.
my affidavit.
That's the reason
opposition,
why
they filed.
Within a week from date, let the matter now reply already here.
This is
Let-
like GA3. I mean, like GA4 was my application for the demurrer for dismissal of the suit. Lordship, once I can argue that that is
What is the GA3?
GA3 is judgment upon
My
admission.
application judgment upon
Both
application.
has to be
But they have moved it. I have to respond to it.
In
And
the affidavit, they have admitted my
GA4,
whole
I had
case,
moved. They have responded. I will give reply.
Different affidavit altogether. They had not admitted my whole case, my lord.
GA4.
GA4 is my application. They have given already responded to that. So I will just give my reply, and that can be this chapter can be over. Then that I on whenever the if I will only argue GA4, GA3. So Millard in GA4, may I lordship permits me my move, Millard. In GA4, Millard, my application's contention was the 3 points I argued. One is Millard.
GA4 also you are already argued.
Yes, I moved the application. They
Ah.
responded. I'll going to give reply to their response. So I'll not take long. I'll just indicate some points. That's all. Because what I have to give reply to their
GA4 also you have also submitted.
yes.
Only the judgment, my lord, he has to
Yes,
distinguish.
you
my
have to
lord.
distinguish the
I mean,
judgment.
reply, yes. So I'm just because that has been 3 months. I think Lordship has last had this 2 months. Lordship last had this matter on merits. So I'll just in nutshell I'll just reiterate my argument which I had made. My point, threefold point. First was that the agreement was was executed between the defendants and a third party. Suit filed by someone who was not part of
Difference in the name.
So it's a different
That is the
entity.
main question.
Name and a different entity.
Correct.
So there is no privity of contract between the defendant and the plaintiff, and therefore plaintiff does not have a right to sue. Cause of action is not there. That's my first point. Second was limitation, and third point was commercial suit. There are 3 arguments I made. That in respect of the first point, the different name, their contention, their only response was that it's a typographical mistake, and that's their pleading in the plaint as well. Lordship had seen the paragraph of the plaint. That my encounter, I'm saying that a typographical mistake can happen once, but if a same mistake happens in series of agreements, if Lordship sees in all the agreements, there are prior agreements also. Those prior agreements also contain name of that third party. Kindly sees page 39, page 58. These are all prior agreements. In
Yes.
all those agreements, the same person is agreeing.
Yes.
So this can't be a mistake. It's a one-off mistake. It's not the case. Parties were consciously agreeing to execute these agreements between themselves. And now when suit comes, it comes from a different entity. The last one document that I did not, I missed out from showing Millard, page 114. That's the pre-suit notice.
Notice that also
Notice is also issued by,
I
and in
recall.
the notice they do not say that is a mistake.
In my
This-
note it is there.
Yes.
You start from page 63,
Yes,
then
Millard.
158,
Yes.
then 119,
Yes.
then 123,
Absolutely, Millard. Absolutely.
39,
Lordship has
58,
all these notes.
80, 114,
Yes.
77.
Yes, and that in the my contention is that in the plaint for the first time they said that was a mistake. Also in the pre-suit notice, they did not talk about any mistake. They proceeded as if that was the right entity. So that's one. So it's not a mistake. That was their argument. And the judgment showed on the basis of that argument is that no one is entitled to take benefit of a mistake. That's the proposition of law. I am saying it's not a mistake because consciously 6 times say mistakes can't happen. Once I would have understood, but they are agreeing again and again and again between the same party. It can't be a mistake. Parties are deliberately executed in that manner. I do not know the reason. Maybe income tax, maybe some other liabilities. I do not know. But be that as it may, the entity, the plaintiff was not party to any of those agreements. None of those agreements. And the suit, pre-suit notice, the only pre-suit notice which was issued was also issued by this. And that also does not say of any mistake. Mistake first time they said in the plaint. That's first, Millard. Secondly, Millard, the question of limitation. The question of limitation, Millard, was sought to be argued that it's a mortgage suit. And because it's a mortgage suit, the period of 3 years is not the period of limitation. The limitation should be, Millard, counted as 12 years. Millard, Article 65 was shown of the Limitation Act. Now, Millard, in order to, Millard, qualify this suit as a mortgage suit, Lordship knows the Civil Procedure Code provides for it. Order 34. It's a legal argument, so I'm giving a legal answer, Millard. Kindly, Millard, if Lordship takes the CPC once, Millard, Order 34. Millard would see that, Millard, 3 kinds of suit: foreclosure, sale, and redemption. The Order 34 Rule 1.
Yes.
3 kinds of suit can be under the head of mortgage: foreclosure, sale, and redemption. Now, Millard, if Lordship takes the corresponding form of pleadings given in CPC under Appendix A, form number 45 and form number 46. I'll show the prayers of this plaint and the prayer it should have been had it been a mortgage suit.
Order 34.
Order 34, Rule 1, 3 kinds of suit.
Subject to the provision on all the interest, either the mortgage, security, or the right of redemption.
Yes, there are 3 rights under mortgage. Now, Millard, which one of these three is being, Millard, is being sued for in this suit? That's what your Lordship has to, Millard, understand from the prayer of the plaint, not from the submissions of the advocate from the bar. Now, Millard, kindly comes to Appendix A of the CPC. It's towards the end, Millard, Appendix A of the CPC, form number 45 and 46.
Form number 45
and 46, Millard. These are the 2 forms, Millard, provided in the CPC, which, Millard, in which manner, Millard, the plaint should have been drafted had it been a plaint for mortgage. 45 and 46. But it has been casually said that it's a suit for mortgage. But in order to make it a suit for mortgage, Millard,
Appendix
A, form number 45 and 46. It's after Order 51. Appendix is starts after Order 51. Thereafter, the pleadings and then 45 and 46. These are 2 forms provided in CPC. One is, Millard, for foreclosure or sale. The other one is redemption. If Lordship, may I hand over my copy?
Yes.
But for foreclosure or sale, kindly comes to the next page, Millard, at CL number 6, the plaint's prayer is given. These should have been the prayers of the plaint, Millard. And these pleadings should be there. If the plaintiff wanted to sue for mortgage, this should be plaintiff's pleading, and this should be the plaintiff's prayers. And the next form, redemption. The CPC, the Civil Procedure Code, is very specific. It can't be a suit of mortgage unless you plead your plaint in this fashion. 2 forms are provided with prayers. These should have been your prayers, and this should have been your plaint. Now, in light of this, kindly seize the plaint, Millard.
Form 45, no?
Yes, 45 and 46. Two forms provided.
That is a redemption.
Yeah, well, I do not know which one they say because they said suit for mortgage. So mortgage has three category of suits: sale, redemption, and foreclosure.
Yes.
But in the plaint, Millard, now if Lordship sees the forms, kindly now comes to Millard page 29 of the plaint of the application, which has the prayers of the plaint. I've annexed the plaint. Page 29 has the prayers. At internal page 21 of the plaint.
Plaint where? Page number?
29 of the application, Millard. And if Lordship has the plaint, then page 21.
29, yes.
The prayers of the plaint, Millard.
Decree.
Yes. First is a money decree. See, simplicity recovery of money. Second is perpetual injunction. Kindly now sees, Millard, where is the scope of injunction in these forms, Millard. 45 and if I leave 46 and 45, Millard, there is no scope for any injunction, Millard. It's only either you pay or in default I'll foreclose. Where is the pay for foreclosure, Millard?
D.
But D is redemption. My line friend probably had not read the forms. D is redemption. D is not Millard foreclosure. There is no prayer for it, Millard.
D of?
But prayer D, Millard, he probably refers to as
redemption.
That's not foreclosure. Millard. My friend is wrong there. So, Millard, prayer for foreclosure, payment is in alternative. That is not the framing of the suit. Kindly see prayer A, simplicity recovery of money. Prayer B is injunction. Prayer C is interest. Prayer D is redemption. Now, Millard, I'll come to that also. Prayer E is, Millard, again decree immovable properties be sold, money be realized. Prayer F is again injunction, Millard, and then attachment. There is no prayer for Millard foreclosure of mortgage. So, Millard, my learned friend does not sue me for mortgage. He doesn't want foreclosure of mortgage. He wants money. It's a suit for recovery of money. That's his prayer A, and there is no corresponding prayer for foreclosure.
Yes.
And Millard, secondly, Millard, if my learned friend now has to say that it's form 46 redemption, Millard kindly sees that what is the form number 46 kindly sees, Millard.
Yes.
It's only for the land first, the immovable property, and the other, Millard, is possession. The defendant has taken possession in law, he has to say, and the third is redeem the said person to have the same reconvenced to him. Now, Millard, this prayer D, kindly read. The defendant number 1 should absolutely be debarred of her right to redeem the mortgage. He is asking defendant from being debarred to redeem defendant's mortgage. He is not talking about him. He doesn't want possession. Kindly read the prayer D carefully, Millard. Defendant number 1 be absolutely debarred of her rights to redeem the mortgage. The plaintiff is not seeking any right of redemption. He is restraining defendant from redeeming the properties. So, Millard, the prayer of the prayer 46 is just the opposite. They could have sued they could have sought redemption in their favor, possession in their favor, not the other way around. It's absolutely the opposite of what the pleadings say, Millard. So, Millard, it's just a casual statement from the bar. It's only, Millard, strike them, Millard, when I argued limitation that some way or the other they have to save it. So, mortgage, Millard, gives them 12 years time. So, it's a suit for mortgage without there being any pleading. It's deed of mortgage, but they are suing for recovery of money. They are not suing for it.
This is not a redemption.
Yes.
This is a way of, we can say, the
They are
interim.
They are trying to stop me from
Restraining
selling. That's
for
all.
selling. That's
They are not, Millard, trying to redeem
not
the
the
property.
redemption.
Yes. So, Millard, for 46 is not applicable, and foreclosure, Lordship has seen that prayer is absent. So, it's not a suit for mortgage. If it's not a suit for mortgage, then, Millard, it should have been, Lordship knows, 3 years. Suit is expressly barred because that's the only explanation given. No other explanation given, Millard. Why not? Why they should get an extension? Nothing given. Its suit is categorically, it's filed in 2024. The mortgage deed, Millard, is of 2016.
Okay.
And Millard, notice of notice of suit was given in 2018. So it cannot be, Millard, saved by, Millard, in that manner as well. That's my argument, Millard, in answer to their legal argument of limitation. Oh, and Millard, last thing, and one more point in respect of mortgage is that, Millard, if they now say it's a suit for mortgage, the Commercial Court Act, Millard, doesn't consider the section 2. Lordship has a copy, can give, Millard. Section 2 doesn't consider the case of mortgage. So, Millard, that's an additional point. If you, Lordship holds that's a suit for mortgage, Then your lordship has to consider if mortgage can be covered under Milord Commercial Codes Act, a suit for mortgage. It doesn't qualify in under these Milord heads. But C1, Milord, 1 is suit between bankers and merchants. 2, Milord, merchandise. 3, Milord, admiralty. 4, aircrafts. 5, carriage of goods. 6, Milord, construction agreements. 7, immovable property used exclusively for trade and commerce. 7, Milord, franchising agreement. 9.
This agreement ended between whom?
Between the defendants and a third party who is not here before your lordship. The plaintiff was not the party to the agreement. Plaintiff says that there was a mistake in the agreement.
That's why if we go by that, if it's not a mistake, it is a mistake.
If it's a mistake, then between us.
Between you.
Yes.
If it is between you,
Yes.
if the court is held, no, it is between you. So why it is not coming under one?
But because he is not a financer.
No.
He is not his
Transaction of merchant, bankers, financer, traders.
He is none of these because he doesn't say I am one of these. In the plaint, he did not say I am a banker or a merchant or a financer.
Describe himself as a
kindly sees the plaint Milord at page. Milord, it starts from page 12.
Business of the real estate.
Yes, he is not says that I am in the business of financing. I can also disclose the copy of. I have taken out the copy.
What is the mortgage deed?
But deed of mortgage, the correct one, lordship would find last one, the lordship on page 62 has the 62 similar.
Yeah.
The mortgage deed.
Mortgage deed. So it is a mercantile document.
Document is mercantile. I am not denying that. I am not denying that. I am saying that if the issue of mortgage is involved,
Checks are involved. It's a mercantile.
that these
Checks are involved.
these fittings are absent. That's my third point in commercial. Commercial.
Wait, what?
There are checks, my lord, which are mercantile documents, my lord.
Checks cannot be.
Which they are given, my lord. Security, my lord.
But who issued those checks? It's a completely different.
Right.
entity.
You have issued the checks.
I have issued to someone else. You are
check.
You are my
the checks.
But this I did not argue or even stand up when they were arguing. This is an interruption that should not be happening. I did not interrupt them when they argued for 2 days.
You have to say the right facts.
No, kindly take your seat because you argued for 2 days.
Right
I did not
facts.
disturb
Say
you.
the right facts.
That you had the chance. You said enough. Now let me submit.
Why not 7?
Yes, 7, my lord. I am showing that.
Agreement relating to the immovable properties used
Yes,
for
sir. This
exclusive-
agreement is not exclusively of. That is my other argument for mortgage. My lord, foreclosure. I was arguing that it should have only be immovable. This mortgage did not involve shares and many other things. Not immovable only. Only one immovable property is involved. Rest of them are all shares.
Whatever it may be.
Yes, my lord. So there. This should have been there. My lord, 7 is
if shares then
exclusively trade or commerce. Exclusively trade or commerce.
Shares.
There is no share transfer.
Hmm.
The issue is I am paying you money. You hold it and in guarantee you give these shares and land. Keep it for mortgage.
Shareholding.
Yes.
Shareholding. Then come to the 12.
But again, not a shareholder. The shareholders agreement is between me and him for transfer of shares. Here, the shares are not being transferred. I am holding it in mortgage as a guarantee to the agreement.
Whatever it may be.
It's not a shareholders agreement. That's my submission.
Okay.
This agreement is not a shareholders agreement.
Okay.
This agreement is a shares are held for guarantee. So, if lordship holds it as a commercial mortgage, then this issue may come. Lordship has taken the note of page 117. These checks, 117 to 119, the checks that my friend referred to, those are the checks issued in favor of someone else, and those were dishonored. So, if I issue check to X, Y can't sue me on the basis of those checks. That's my lordship probably has recorded that into the argument. Apart from that, I lastly argued on the point of commercial suit that there is no response to that. But even then, I just for the sake of at the sake of repetition, none of the pleading why it's a commercial suit, not even a single paragraph is there in the plaint.
Yes. Not required.
So that paragraph of the why is it a commercial suit, it's not there. Lordship can't figure it out from the plaint. If this continuous commentary stops, it would be easier for me to argue. There is not even a single sentence in the plaint why it's a commercial suit. The plaintiff and does not say that the relationship.
That you already argued.
Yes, that was my part. There is no response.
No pleading about the commercial.
And lastly, because while responding to my application under Order 711, they wanted to argue that there is an admission on my part, so I am not entitled to this this prayer. But I would say that admission One, it was made in a different application, and I had withdrawn that application already by filing a subsequent affidavit. That affidavit I will show that when I have reaffirmed my affidavit and filed it. But my lord, on the lordship will then have to go beyond the plaint, because that affidavit came subsequent to the plaint. None of the document that lordship was on last occasion shown regarding payment are part of the plaint. It's a commercial suit. New documents can't be disclosed at this stage. Plaint does not disclose those documents or does not even refer to those documents. Now, if they want to rely upon a subsequent admission, which I have withdrawn, that admission lordship subject to correction probably cannot look into, because those are not part of the plaint.
What admission?
But they say that in judgment in the application to injunction, I filed an affidavit, and I said that I have admitted this transaction. That's their submission. In reality, what happened? I filed an unsettled draft.
No.
Mistakenly.
No.
Please. Kindly, this interruption should stop. I didn't interrupt them. So, in reality, what happened? I forwarded an unsettled draft. It was not filed, but it was affirmed. Immediately, on the same day, I wrote to them, kindly don't rely upon this because his unsettled draft mistakenly affirmed. And with that, I reaffirmed another affidavit and filed it in court. All these are recorded in court's order. I will show it when that application of Lord GA number 3 will be heard. Now, on the basis of that affidavit, they want to say that because there is an admission, I can't argue Order 7, Rule 11. Now, in answer to that, I am saying that probably this is incorrect, because Order 7, Rule 11, Lordship can only look into the plaint. This is settled law. I am carrying judgments of Supreme Court. If Lordship permits, I can cite it. But this is too settled, my lord, that if Lordship can't go beyond the plaint. Whatever is there in the plaint, as on this date, Lordship can only look into the. If Lordship restricts Lordship's view to the contents of the plaint, then, my lord, it's not a mortgage suit. It has to be held as a suit for recovery of money. It's beyond 3 years ex facie, and there is no explanation, neither oral nor in the plaint. And 3, there is no pleading of commercial suit. And 4, the plaintiff has no agreement with the defendant. 7, except that one sentence in the plaint that it was mistakenly recorded. Apart from that, no contemporaneous document which talks about this same mistake. Notice given.
With regard to that mistake, whether the same plaintiff or the parties other,
yes,
can in this interlocutory application it can be decided?
It may not be decided. It's a question of cause of action. I would say it may not be decided in my favor. Lordship may send it for trial, that if they can prove the mistake, that can be a view. But so far as the question of limitation, there cannot be an alternative view, because that's ex facie. From the date Lordship can see 16 agreement, 18 termination, 22 suit. There is no computation given in the plaint. No attempt has been made in the plaint to explain the limitation. No attempt has been made except that oral submission from the bar.
Action arose?
According to them, 2018.
2018.
That paragraph from the plaint doesn't say any date of cause of action. The termination is of 2018. Kindly sees
2018.
18. Kindly sees
Which date?
The date is
page 133 is my letter, my lord.
Plaint.
That paragraph is, they have not said. Paragraph 15, kindly sees. Before that, the agreements, and then non-payment, and then 14 and 15.
Loan of interest, so.
Redemption notices of, my lord.
Now, my lord, kindly see space paragraph 26 in this.
May
with this
2022.
But kindly.
Yes, I am asking the question.
14, 15 and 26. 26 refers dates very categorically. The plaintiff by all its notices dated 2018 August, then 22. Paragraph 26 of the plaint. The plaintiff further states the plaintiff had by all its notices dated 13th August 2018. The next date is 2022. Between this period, the limitation has expired. They were probably waiting.
No. Plaintiff had by all its notice dated 13th August 2018.
And the next date is 2022. So if it is a continuous cause of action, it had to be within 3 years. 18 and 22 have difference is 4 years. Yes, 18 is the last.
18 is the last notice.
Thereafter,
subsequently has issued 2022.
Yeah, 2022,
so if it is taken into 18,
yes.
So 21 August 2021.
Yes, but the suit is filed in 2022.
August 2021.
Yes.
Correct.
Getting the benefit of
August 2021.
Yes, my lord.
Then the COVID period
It
Should
was
have,
there.
could have been, but that's not their case. In the plaint is not said so. That because of this reason I was stopped. Kindly see the plaint, my lord. That reading is absent in the plaint. In fact, my lord, they also trying to, my lord, bypass the issue of arbitration with the concept of mortgage. But it's not a suit for mortgage. So arbitration clause is also there, admittedly paragraph 33. They also admitted in the plaint.
You have not filed a section.
I have not filed it yet because I am only appearing for one defendant. It can't be done by one person. It has to be all parties have to come here. That's the reason why I can't file the application. But the clause is there and section 5 and 8 is very clear. Without the application, Lordship can refer if Lordship finds an arbitration clause. That I don't need to apply.
Yes.
So these are the.
That's all.
That's all. Urgency, mediation, those urgency pleadings for mediation and all that. Those are all absent. That paragraph is there, but it's very vague and they don't say what is the urgency.
But with
Paragraph 34, my lord, I have seen.
But the leave granted.
That maybe
Leave granted.
leave was granted must be. So my application is there for my lord, the rejection of the plaint, and my lord, all consequent leave and everything, my lord, will be. That way, my lord. So Lordship restricts Lordship's view only to the plaint. Then, my lord, there leaves no doubt that it's a clear case of suit for barred by limitation. Cause of action, even if I may not give them for some, my lord, benefit of doubt, that if it can be, my lord, explained in trial, but my lord, limitation, how can it be?
That will be decided in that. Yes.
That is not clear.
With regard to, my lord, the first statement that
facts বলবে
কি করবো
বলো
তুমি
বলো
fact
না
of
বলো
unlawful করেছো
বলো
reply them
বলো আরে
বলতে
বলো
হবে
বলো I'll not disturb you.
Kindly, my lord, takes, my lord, my notice of page 133. That is the notice for redemption of mortgage. It has been made on May 23rd, page 133
133.
of the blood application, my lord. Annexure I, my lord. It is dated, my lord, May 23rd, 2022.
That's why, see, when your cause of action arose,
When I ask for redemption of the mortgage, my lord. When I'm asking
what
for,
about the 13th August
kindly, my
2018
lord, take that
notice?
notice even. What is that notice, my lord?
Yes, that condition, because that is the crucial point he has
Showing
raised.
that, my lord, notice, my lord. My lord, page 114, my lord.
Yes. Demand notice.
For payment of 5 lakhs,
5
sorry,
crore
5
40
crore
lakhs.
40,000, my lord.
40 lakhs. If you reduce to 5 lakhs, he is ready to pay.
No, cannot be. Kindly see, there is no question of redemption here. You were saying this is the amount which has been due.
So you admit that this is not the case of recovery, this is a redemption.
Redemption is there, my lord. Redemption, yes, my
The
lord.
case is whether recovery or redemption.
My lord, redemption, my lord. Because, my lord,
Redemption.
I have issued a notice for redemption on mortgage.
So your case is you are admitting that your
It's a mortgage suit, my lord. Yes, my lord, it's a mortgage
court is
suit.
only asking whether this is not a recovery, this is a redemption.
Yes, my lord.
Admission.
Redemption, my lord.
Think of it.
Yes, my lord. My lord, we have pleaded that. That is my plaint case. No plea. I'll show. Now, page 133, my lord. My notice is there, my lord.
Page 133.
133, page 140, my lord. Kindly, my lord, takes, my lord. Thereafter. He says that I have not made any statement, my lord, that with regard to the wrong name, my lord. Kindly, my lord, takes page 141.
Yes.
Although my client completely relied upon
page
140.
Yes.
133 starts, my lord, 140. This is the explanation we have given for the wrong name, my lord. What has been, how fraud has been perpetrated upon us, my lord. Page 140.
Yes. Checks when the presented were dishonored. My client expenses and so. This is a wrong name.
Yes, my lord.
Then
I had given the explanation. He said that no explanation is
where
there.
is the prayer for redemption?
Thereafter, my lord.
One 142.
Yes, my lord.
142.
Last, my lord.
Therefore, my client is entitled to
Possession of the mortgage properties and all.
Correct. Now come to the prayer of the suit.
Yes, my lord. And my lord takes the prayer, my lord. My lord, 30, page 30, paragraph, sorry, prayer E, my lord. Wait, wait.
Page 30.
Yes, my lord.
Yes. Prayer
Decree E, that immovable property is the number one.
Decree that the defendant
He
should
sold and the money.
Decree as against the defendant number one that the immovable property of the defendant number one subject to the statements
Appropriate towards the claim of the
be sold and the money so realized should. That is not the redemption.
And my lord, then my lord,
This will be after the decree.
Attachment.
Attachment.
My lord, D is what my lord I paid for.
D is directing as
Right to redeem the mortgage.
One type of the interim order. Decree directing the decree that the defendant should absolutely be debarred for right from redeem. So you are taking you are on the decree against you only.
Paragraph 27, the pleadings are there. It's not that. Not,
27.
27, yes. No, pleadings are there.
No, pleading, but where is the prayer for redemption? Mortgage money loan due
Pleading is also in the same form. Pleading is also the same form. The opposite pleading.
Plaintiff is entitled to a decree that they should be absolutely be debarred her right to redeem. If this decree will be passed, what you will get the under the redemption?
The typo, so no.
Who
Yes,
settled the plaint?
27 was fine, Lord. And my lord, kindly my lord takes what is the mortgage about, my lord? Mortgage is about the shares and the money which has been paid, and my lord, the tenanted properties, my lord. So, my lord, shares, my lord.
That's why the simplicity, the property is involved in the mortgage. So that's why you wanted the redemption of the property in question because the payment was not been made, the check was dishonored. This is a simplicity. We go
Yes,
by
my lord.
that.
One check was dishonored, number one, my
Dishonored.
lord. The shares has to be transferred to my name.
Correct. So share is not on transfer. So you wanted the property is to be redeemed in your favor.
Now, my lord, may I say, my lord? My lord, the shares he had already issued, my lord. The original share certificates are with us, my lord. And my lord, the share transfer deeds is also with us, my lord. So, my lord, they've already done the act of transferring the shares in my name. I have to lodge before the company, become a shareholder of the company.
So that cannot be decided.
I cannot be done here. Therefore, my lord, that is the reason, my lord, I couldn't have asked for the prayer.
Correct.
For lodging of the shares.
That's why with regard to the share, this court cannot.
I cannot, my lord. I cannot, my lord. I cannot ask even for the prayer. So therefore, my lord, that is the reason, my lord, the prayer E, my lord, comes into effect, my lord.
The prayer E, that's why.
Only, my lord, the immovable properties are there. I have to come towards, if I have to redeem the mortgage, my lord, where immovable properties are involved, my lord, I have to, my lord.
It's correct. It is kindly see the read D.
Decree against the defendant number one that the immovable properties of the defendant number one, subject to statements made in paragraph 5D, here to be sold and the money be so realized should be appropriated towards the claim. My claim is thereof, my lord, 9 crores odd, my lord. Prayer A, my lord.
Decree against the defendant number 1 that the immovable properties of the defendant are subject to the statement being made under 5D hereof be sold and the money. So this is a realization.
Yes, my lord.
So
I'm
if it is realization the money, then it will again come to the prayer A.
Yes,
Decree.
the decree is coming. So it's
Decree with regard to the recovery.
right, my lord.
If it is a recovery of the money, what is the limitation period?
My lord, this recovery of money, but I am asking for redemption. Until I ask for redemption, my lord, my mortgage deed cannot be redeemed, my lord. I cannot ask for any prayers with regard to the mortgage deed until and unless, my lord, I have to redeem it, my lord. I cannot ask for selling of the properties involved, the tenanted properties will be involved. I cannot ask for any other price, my lord.
So that's why E. You are telling that you cannot ask for the selling out. What is the E?
That is the reason, my lord, I have asked for, my lord, e-prayer. That's the reason, my lord, I asked for these properties to be sold. And the money realized to be paid to me. And also, my lord, the 9 crores odd, my lord, which we have given as a loan to them, my lord.
Okay. Okay, next.
And my lord, kindly, my lord, takes page 1, my lord, 158 once, my lord. Okay. Oh, हाँ, ठीक है. Now, my lord, 158, my lord. My lord, kindly, my lord, sees, my lord, the Sushila Jain, my lord, the letters and the date it was issued, my lord. Yes, yes, kindly see the text. Yes, yes, my lord. Yeah, oh, what does it matter?
2016.
2018, my lord, the last date, my lord. How does it matter?
The letter is dated 2016.
Thereafter,
The letter is dated 2016.
ঠিক আছে?
Forged document. The forged document.
And now, my lord, thereafter, my lord, these were returned and it takes 119 once thereafter.
18 চেকের কথা 16 কি বলি?
Annexure যে প্রিন্ট আছে? Can he take the checks which was handed over thereafter? 119, my lord.
No, 158.
Yes, 158, the checks which were given, thereafter were replaced, my lord. And 119 is the checks. And my lord, can you take page 23 with regard to the pleadings, my lord?
118.
It is within limitation, know that.
Same letter.
118 kindly takes, my lord. Sorry, page 23, paragraph 18. I'll show the pleading once first, my lord. Thereafter, I'll take the checks, my lord.
Page 18.
Page 23, paragraph 18.
Yes. When the plaintiff further persuaded the defendant after the first or second wave of pandemic, once again issued check on 24th of November.
Check several dated, such and such, 2021. With 50 lakhs each in favor of, again, my lord, however, in view of the wrong name of the beneficiary, the checks which was internationally defendant number 1, the sections were both dated such and such, were also dishonored for the same reason, pay name deferred. So, my lord, they have acknowledged. It's not that they are not acknowledged.
So, page 18.
Page 8,
paragraph 18.
Paragraph 18 and Annexure G is 119.
119.
Even if it is a money claim which they are saying, my lord.
119 is the
The
check.
checks, my lord. The checks dated, my lord. Okay.
50 lakhs.
2021. But the acknowledgement is there. The acknowledgement of dues are there. And that is within the time, my lord.
Yes.
It's within the time. If they are saying 2018, their cause of action starts. 2021, my lord, the limitation is still there.
Why?
2018, my lord. Can you, my lord, take the date?
August 2021. 13th August 18. 13th
my
August 18 is the last notice.
Section 25 কোথায় গেল? Limitation Act কোথায়?
The Lordship also remembers I cited a judgment on the first time.
Wait.
In the judgment, I said the question of extension of limitation won't happen because that has to come within the period of 3 years. After 3 years, there can't be any extension.
That's
Section
why-
25 is being shown.
Kindly come to the page 25 and 26.
That argument I've already made.
Page 25. Page 25, that is a 13th August 2018 notice.
Yes, my lord.
Correct.
Yes, my lord.
So if we go by the 13th August 2000 notice, the 3 years, 12th August 2020, 21.
Yes, my lord.
Correct. Then this is, we are telling that 26 November 2021.
Yes, my lord. 2021. And the suit was filed in 2022.
So your first cause of action already completed.
My lord, first of all, my lord, the 80 notice, my lord, was not a redemption notice. I asked, my lord, they have not paid. This is the amount which was due. 5 crores odd, which was due.
Okay.
Thereafter, my lord, they had issued fresh checks to me, my lord. 2021, my lord, they have issued fresh checks to me. These are fresh checks which have issued to me, my lord. In lieu of the other checks which was returned to them. Again, my lord, they had issued in a wrong name. So therefore, my lord, we issued a notice stating that you have issued in wrong name. You should have issued in the right name. It's completely fraud on your part. That is 2022 notice. And we have filed the suit.
Yes. Okay.
So, my lord, limitation, my lord, if my lord, limitation would have come, my lord, if I'm talking as a mortgage, if I'm talking normal suit, my lord, 3 years time, 3 years time would not have expired, my lord. Because 2021, they're acknowledging the debt, my lord. And by acknowledging the debt, they're issuing fresh checks again. My lord, and my lord, without taking, my lord, the Honorable Supreme Court judgment, my lord, which is there of 2022, my lord, that, my lord, the COVID period was there. If my limitation also, my lord, have expires within the period of time, my lord, I get the extension till, my lord, to file the suit, my lord. But be that as it may, my lord, I'm not going there. However, my lord, the suit which was filed in 2022 was within the time of limitation. The reason is that 2021, they had issued a check in my favor. And that's acknowledgement of debt. And that acknowledgement came within time. And my lord,
That's all.
my lord, regarding my lord, regarding commercial suit, my lord, I'll just show one page, my lord, once, my lord. I'm sorry, my lord. Sorry, my lord. I have to show one page, my lord. And I showed the date.
expire করবে 21 তে expire করবে 22nd এ February last date এর পরে তাও 90 days we had
এটা তো আছে সুপ্রিম কোর্ট আছে the Supreme Court judgment is there, my lord, which we had time, my lord, for, my lord, because the
7/21
হ্যাঁ তো ঠিকই তো আছে
1990 April 21st it was
yes ঠিক আছে
20 days after 28th February
for filing what are you saying now, my lord, with regard to Commercial Courts Act, my lord, Commercial Courts Act, my lord, No, this is a agreement, my lord. I've seen, my lord. The shareholder is being transferred. That's one. That is one of the aspects, my lord. It's transfer of shares.
Under which clause?
My lord, VII. Agreement relating to immovable property using exclusively in trade of
VII.
commerce.
VII.
Yes, my lord.
Seven.
The 7, my lord.
Hmm.
Agreements relating to immovable property used exclusively in trade or commerce, my lord. This property, my lord, may I show from the deed, it is used in commercial, my lord. From the, my lord, the mortgage deed. Any, my lord, takes, my lord? The mortgage deed once. You put a mark. ये ये नहीं
लाइन लिखनी प्लेन डेट है
दरकार नहीं लिखा दरकार नहीं है ना 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 look kindly takes the schedule once আমার ই shareholder अरे any my lord takes my lord (49) the period when 49 recitals are there with regard to the properties, my lord. From 5A.
49 is a unregistered mortgage deed. Probably he wants to show 62.
62, my lord. Him 62. I'll show that from same things are being done.
Unregistered deed, court can't look into that document. What my landlord friend is saying.
You want to rely upon that document, sir. You are relying upon that document. You are relying upon that document. Kindly, my lord, takes, my lord, page 63. 4, my lord. 4. अरे भाई তোরা কি আমাকে বলবি না ওখানে ডিসকাস করতে হলে তোরা
Yes.
Lord, kindly, my lord, takes, my lord, the registered mortgage deed, my lord.
Yes,
But my different my lord, matching the pages and thing, my lord.
There is no recital to the agreement.
To the clause.
কোন 62 আরে কোনটাকে ম্যাচ করছে না এটা কোনটা এটা এটা কোনটা কোন অ্যাপ্লিকেশনটা বলছিস not we are getting confused because my lord we are showing GA3, my lord.
I am in JFO.
Yes, my lord.
Page 70, page 77 there.
My lord, page should be, my lord, 56, internal page 18 of the agreement. Page 71, my lord, 72. ওটাই কি না এটাও নয় 72 কোথায় আছে ভাই GA3, my lord, page 56, my lord, but here, my lord, just trying to find out because, my lord,
Internal page of the deed. Tell
page
me.
71, kindly, my lord, takes here.
Internal page.
Internal page 10 of the deed.
Which clause?
My lord, deed for the witnesses, my lord.
Yes.
Of the share tenancy right of the mortgagor in the go down let out on rent. My lord, in the middle part, my lord.
Agreed that declared between the parties to cause surrender The mortgage shall become the owner of the
Right.
property.
Upon recording
Tenancy right of the mortgager in the godown let out on the rent by the said company. Commercial.
direct tenant, nominee becomes 51%, holding.
And have the surrender. No, that is the condition.
Right, but because it's a tenanted property which is involved.
Maybe. What is the condition between you and the defendant as a commercial? That is a condition. That will be surrender. This will be surrender. Whatever it may be.
The conditions, my lord, at page 77, 78, Roman 4, my lord.
Correct.
Roman 4 is there. Take a check. I have to show the movable property that is there.
Come ready next day.
Yes, my lord, I'll come back, my lord.
Sons suffering for the plaintiff, sons suffering for the defendant. Defendant has concluded his argument with regard to GA4 of 2024. Police of counsel for the plaintiff press for time. According to case adjourned. Let the matter appear on 28th January.
28. But in the meantime, with that.
That already directed.
Yes.
GA4 up to the.
Why?
4 up. Okay. 4.
With my lords, I'll just my lord, item 20, my lord, the next matter, my lord. My lord, I'm appearing for the respondent. My lord friend is appearing for the petitioner, my lord. My lord, because of some medical emergencies, my lord, the certain instructions are required, my lord, from the respondent, my lord. My lord, I'm humbly praying if the matter can be taken up on 20th of January, my lord.
But I had concluded my submissions in GA.
My learned friend is concluded.
It's an application for injunction and security. But I had concluded my submission. Mr. Gupta was appearing.
Item number 20, as per the prayer made by the counsel for the
respondent, my lord.
Defendant, the case adjourned. Let the matter appear on 20 January 2020.
Deeply obliged, my lord.
Grateful.
Next.
My lord, item number 21, I'm appearing on behalf of the plaintiff, my lord. My lord, I'm humbly seeking a nod today in this matter.
It will already.
Well, this was already part heard. Mr. Banerjee was making submissions on the last occasion.
Come on Monday.
Very well.
Not today. Because the other fixed matters are there.
Very well.
Grateful, my lord.
Item number 43 is not commercial. I am for the petitioner, my lord.
Item number?
I am for the petitioner. It's an application for probate matter. An order was passed for amendment of the cost settle of the probate application, my lord. The difficulty is, my lord, if you lordship kindly come to page 5, my lord.
Which one?
Item number 43.
Department director to show.
Yes, my lord.
The GA1 and
in amendment was carried out also, my lord. My lord, difficulty is, if you lordship kindly come to page 5, my lord.
Page 5 of?
Probate application.
Then?
Rama Bhattacharya, she has given the consent, my lord, because of amendment. Fresh consent affidavit is required, my lord. She is staying in Bangalore, aged lady, my lord. She is not able to come to Calcutta, my lord. Therefore, further consent affidavit with amendment cost settle is required, my lord. He will.
So what you want?
My lord, I am praying leave that a fresh consent affidavit is required and leave may be granted.
As per the prayer made by the counsel for the petitioner submitted, the original PLA application has been amended, and as such, the one of the legal heirs, namely Rama Bhattacharya, has to file
fresh consent
affidavit, and he prays for time to file the same within a period of
2 weeks, my lord.
2 weeks.
And from
we have the submission made by the counsel for the petitioner, that is
adjourned. Said affidavit by notary.
Let the matter appear on 29th January 2025. Next.
Lordship, I am appearing in this matter, Lordship. It is a probate application. All the formalities been complied with before summer vacation. No caveat certificate also been issued by the department. I am praying for prayer A, grant of probate.
Where is the will?
Lordship, will is at page number is attached. Is attached with the application. It is at
What is the date of the will?
date of the will is Lordship 1st October 2019.
Yes. Where is the name of the executor?
The name of the executor is executrix. It is a lady, Lordship.
Where her name is appearing?
Rimi Poddar.
Where in the will where it is mentioned she is the executrix? Rimi Poddar appointed to sole executrix. Yes. How many legal years?
Lordship, no legal years, Lordship. She was bachelor, Lordship.
No brother, sister?
No, Lordship. Nobody.
Where is the affidavit of the attesting witness?
Is attached, Lordship. Been complied with and attached, Lordship. Lordship, both attesting witness, one is Sanjoy Khila and another is both two attesting witness been attached, Lordship. Sanjoy Khila.
When she died?
As per death certificate, Lordship, died,
she was unmarried?
Yes, Lordship. Died on 10th October 2020.
So appearing for the petitioner. The petitioner has filed the present application for grant of probate of the last will and testament of the testatrix Durga Bhaumik alias Durga Chand Bhaumik, dated Durga Chand Bhaumik, dated 1st of October 2019. Full counsel for the petition submitted. The testatrix was unmarried and she died leaving behind no legal heirs. He submits that the testatrix has executed her last will and testament in presence of two attesting witnesses by appointing the petitioner as sole executrix of her last will while possessing good health and fit state of mind. Counsel for the petition submit that special citation and general citations were issued, but in spite of the citation, none has come forward to object for grant of probate, and accordingly, the department has submitted no caveat certificate dated 2nd December 2024, stating that no caveat has been entered against the grant of probate of the last will and testament. The counsel for the petitioner submitted both the attesting witnesses have filed their affidavit stating that the testatrix has executed her last will and testament in their presence by appointing the petitioner as sole executrix while possessing good health and fit state of mind. Had the learned counsel for the petitioner peruse the original counsel for the petitioner submitted the testatrix died on 10th of October 2020. Had the learned counsel for the petitioner perused the original will, original death certificate, original
affidavit of the attesting witnesses and the no caveat certificate issued by the department. This court find that in spite of issuance of citations, none has appeared to object for grant of probate. Full stop. To prove the will, both the attesting witness have filed their affidavit stating that the testatrix has executed her last will and testament in their presence by appointing the petitioner as sole executrix while possessing good health and fit state of mind. Considering the above, this court finds that the petitioner has proved the case and is entitled to get the probate of the last will and testament dated 1st October 2019. Full stop. The department is directed to issue probate to the petitioner after compliance of all formalities. Full stop. At the time of grant of probate, the copy of the will be made as part of the probate. PLA numbers and disposal. Next.
45. Lordship, in this matter, it is an application for a grant of letter of administration.
Will.
Yes, Lordship, in this matter, the will was executed and the beneficiary of the will is my wife. She expired. Thereafter, my daughter and I am husband, the legal heirs of the executrix who expired. In view of that situation, Lordship, it is an application for grant of letter of administration. The entire thing is explained at paragraph number 8 of the application. And Lordship, at paragraph number 11, the legal heirs of the testator been explained and served all the parties, and they have not came forward to object. Thereafter, Lordship, department issued no caveat certificate.
They have given the no consent affidavit, no?
No, nothing.
What about the attesting witnesses? What about the attesting witness?
Lordship, Lordship, at the attesting witness Shomon Rai Chaudhuri been present and executed the attesting witness affidavit on behalf of the attesting witness and served. Thereafter, Lordship,
Who is the attesting witness?
Lordship, witness number 1, Shomon Rai Chaudhuri. At page number 21, the last, Lordship, Shomon Rai Chaudhuri had the affidavit is attached. He came at High Court and executed the affidavit before the commissioner. Showmohan Roy Chaudhuri.
Yes. When he died, the testator got energy. Where is the death certificate?
Lordship, we executed on 4th December 2013 and expired on 25th October 2017 at paragraph number 7 of the application. It is written, Lordship. Paragraph number 7, page number 4.
So appearing for the petitioner. The petitioner, sole petitioner or petitioner?
No, sole petitioner, Lordship.
Petitioner has filed the present application for grant of letters of administration of the last will and testament dated 4th of December 2013. Counsel for the petitioner submit that the testator Counsel for the petition submit that. After the death of the testator, no steps were taken by either Srimati Bulbul Sen or any persons for grant of probate or letters of administration of the last will and testament dated 4th December 2023, 2013, executed by the testator Gaur Chatterjee. Gaur Chatterjee. Full stop. Full stop. He submitted that in the meantime, the Bulbul Sen died intestate. Bulbul Sen died intestate on 19th of September 2018, leaving behind the legal heirs as mentioned in paragraph 11 of the present application. He submitted the citations were issued, but none of the persons have come forward for raise objection for grant of letters of administration to the petitioner. Police department has submitted no caveat certificate stating that no caveat has been entered against the grant of letters of administration. Huh? No caveat. I mean, there's no caveat certificate. No caveat. Department has submitted no caveat certificate stating that no caveat has been entered against the grant of letters of administration. Full stop. Counsel for the petition submit that the one of the attesting witness of the will, namely Sammohan, S-U-M-O-H-A-N, Sammohan Roy Chaudhary, has executed an affidavit stating that the testator has executed his last will and testament on 4th of December 2023 by possessing good health and fit state of mind. Full stop. Had the learned counsel for the petitioner perused the original will, death certificate of the testator who died on 27th October 2017, death certificate of the Bulbul Sen who died on 9th of November 2018, no caveat certificate issued by the department, and the affidavit of the one of the attesting witness. Considering the above, this court find that from the certificate issue, above this court find that the department has submitted certificate stating that no caveat has been lodged. Full stop. The attesting witness of the will has categorically stated that the testator has executed his last will and testament in his presence and in presence of the another attesting witness while possessing good health and fit state of mind. Considering the above, this court find that the petitioner has proved the will and entitled to get the letters of administration. Accordingly, the department is directed to issue letters of administration subject to furnishing surety of ₹5 lakhs with 2 sureties and upon completion of all formalities. At the time of grant of letters of administration, the copy of the will be made as a part of the administration. PLA number so and so disposed of. Next.
I am on behalf of the petitioner, Lordship. The petitioner has filed an application for grant of letters of administration. It's the only legal heir, and there is no objection. And
what the amendment is?
Amendment was to the effect of the change of address. There was some amendment, correction in the address part. That has been carried out, and order has also been passed and carried out by the department.
Letters of administration of the will, no. Then without
there is no will. There is no will, Lordship.
So how you are connected?
She is the wife.
She is the wife.
Wife of the deceased. The deceased died on 25th May 2021, Lordship.
25th May 2021, and you
Lordship.
filed the application on 2022.
Lordship,
It's still
right.
pending for the 3 years. What you are doing for the 3 years?
Yeah, the last advocate on record died. If you can just see. And then I was handed over.
So what is the necessity of the administration?
Letters of
If
administration.
she is the wife, why, what is the necessity of the
Yeah,
administration?
and for the properties which are lying as it is mentioned in the petition.
Aurobindo Chatterjee. She is the only heir.
She is the only legal heir.
No issue.
No issues. It is also written in the petition.
Notice issued. Caveat?
No caveat.
Where is the no caveat? No caveat certificate obtained. Have you obtained no caveat certificate? Citations issued.
Citation is not required here because there is only one legal heir and
Yes, she is only one legal, but how the court can ascertain she is only one legal heir?
if your lordship wishes, he can definitely. I'll go for that.
Correct.
I'll definitely go for that. But it is here. It is not required. That is only to be mentioned. If you please, if you definitely, we'll go for it.
So appearing for the petitioner. The petitioner has filed the present application for grant of letters of administration of the assets left behind, properties and assets left behind the deceased Aurobindo Chatterjee. Counsel for the petitioner submit that the petitioner is the only legal heir who is the wife of the deceased. This court find that the petitioner is claiming herself is the only legal heirs, but no citations have been issued, and as such, before passing any order for grant of letters of administration, citation is required to be issued. Accordingly, the petitioner is directed to take appropriate steps for issuance of the special and general citation within a week from date.
Much grateful.
Next.
Obliged.
This is my application of probate.
Hmm.
At the time of filing probate, we have annexed the certified copy of the will because it has been lost. Thereafter, we have also made a general diary which is appearing as an annexure that is on 23rd of March 2022. Thereafter, matter came up for hearing and there was a direction to prove this matter by way of solemn format. We have examined first the attesting witness, Mr. Ram Narayan Roy. That is dated 17th of May 2024. My lord, kindly takes up the deposition. My lord, in the said deposition, I have asked, my lord, question number 7, the relevant question number
What
7.
is the name?
Mr. Ram Narayan Roy, the attesting witness, and deposition dated 17 May 2024.
Deposition का है? Ram Narayan Roy.
Ram Narayan Roy.
He is the witness.
One of the attesting witness. My lord, kindly takes up my will.
Let me see. Yes. Where is the will?
This is a register will. In a page number, my lord, 6. Two witnesses. Second witness, Mr. Ram Narayan Roy.
Yes.
Yes, sir. My lord, kindly takes up the deposition dated 17 May 2024. Question number 7, my lord. How do you know that this is the certified copy of the last will of Mr. Ashok Mitra? In reply, my lord, he answered, Ashok Kumar Mitra had told me about this will. Second question, my lord. Are you aware that where the last will was executed? In reply, my lord, he replied, at the office of the Registrar of Assurances at Calcutta, at Kolkata. Next question, have you performed anything in connection with this will? Yes, I have signed on this will. In what capacity? I had signed
on this will as a witness.
Hmm.
Can you please encircle the signature?
Okay, yes. Then what has happened?
Exhibited.
Thereafter?
Thereafter, my lord, we have examined
Hmm.
the the concerned officer of the Register of Assurances Street.
Hmm.
That is deposition dated 19th August 2024.
Hmm.
Miss Tonima Das,
Hmm.
who is the head clerk of Additional Register of Assurances Street,
Hmm.
Kolkata.
Hmm.
My lord, in question, we have asked, what is this document about? She replied, this is the certified copy of the last will dated 17th May 2013 has been issued by Additional Register of Assurances 3 Kolkata.
Hmm.
Wherefrom it appeared that Additional Register of Assurances 3 Kolkata
Hmm.
has issued the certified copy of the last will dated 17th May 2013.
Hmm.
There is a seal of Additional Register of Assurances 3 Kolkata at the last page of the document. There is also a signature at the last page.
Hmm.
Is there any date of issuance? Yes, 4th September 2021. And that has been, my lord, also exhibited. And question number 7, my lord. Is there appearing any CD volume number in the certified copy of the last will? Yes, there is a CD volume number 1, which is appearing in the last page of the document. Thereafter, my lord, we have examined the police personnel, Mr. Nibas Mondol,
Hmm.
from Domdam Police Station. That is deposition dated 12th December 2024.
Hmm. Yes, then?
Have you received any subpoena? Yes. As for document, have you brought any document? Yes. I have taken the document, that is GD, General Diary.
Hmm.
What is the document that you have brought? This is the General Diary entry of lost will. What is the number of the General Diary? 1768. In reply, he has replied. What is the date of, what is the date? 23rd of March 2022. My lord kindly takes up my application wherein I have annexed the General Diary dated 23rd of March 2022 as annexure.
Hmm. Yes.
Yes, my lord, that has been already also exhibited.
Hmm.
My lord kindly takes up the will.
Hmm.
In the will, the deceased appointed his wife as executrix.
Where it is?
Page number 4, last clause, my lord. I now hereby.
Ratna Mitra.
Yes, my lord. Ratna Mitra.
And who is the petitioner herein?
Ratna Mitra.
She is the wife of the executive?
Yes, my lord. Yes.
Ratna Mitra, yes.
Yes, my lord. In my application, my
What
lord,
is the date of the will?
date of the will 17th May 2013.
17 May 2013. When the testator died? 2014. Yes, how many legal years?
February 2014, 2 legal heirs, widow and 1 daughter. Page number 4, my lord, I have mentioned Ratna Mitra, widow of the testator, Suparna Mitra, daughter of the deceased. My lord kindly takes up my affidavit of consent.
Hey, affidavit of consent by. Mix up करके. Affidavit of consent, Sukanya Mitra.
That has been affirmed on 6th January 2023.
Consent affidavit. What about the attesting? He has examined.
Yes, my lord.
Attesting witness is examined.
And his affidavit affirmed on 6th January 2023. Ram Narayan Roy.
So appearing for the petitioner. The petitioner has filed the present application grant of probate of the last will and testament dated 17th May 2013, executed by the testator Ashok Ashok Kumar Mitra, wherein the testator has appointed the petitioner as sole executrix of his last will and testament. Full stop. Counsel for the petition submit that the original will dated 17th May 2013 was lost, and accordingly it was a registered will, is a registered will, but the same was lost. Accordingly, on 23rd of March 2022, a GD was lodged before the officer in charge, Damdam Police Station, Kolkata 28. Counsel for the petitioner submit that the testator died on 1st of February 2014 by leaving behind the petitioner and his daughter as his legal heirs. Counsel for the petitioner submit that the testator has executed his last will and testament in presence of two witnesses while possessing good health and fit state of mind. She submits that the petition, the testator died on, the testator died on 1st of February 2014. Counsel for the petition submit that as the original will was lost and the petitioner is relying upon the certified copy of the will, accordingly the petitioner has examined the one of the attesting witness of the will, namely Ram Narayan Roy, before this court, and during his evidence he has categorically stated that the testator has executed his last will and testament in his presence and in presence of another attesting witness while possessing good health and fit state of mind by appointing the testatrix as sole executrix. Full stop. She submit that during the evidence of the PW1, namely Ram Narayan Roy, the will has been marked as Exhibit A and signature of the testator has been marked as Exhibit A by 1 and the attesting witnesses have been marked as Exhibit A by 2 and A by 3. Police counsel for the petition submit that the petitioner also examined the official of the office of the as additional registrar of assurance, namely Tanima Das, and in her evidence she has categorically stated that the will was duly registered before the additional registrar of assurance, Roman 3, Kolkata on 17th May 2013. Full stop. She has identified the will and the number appearing in the certified copy of the will. Full stop. The number of the will be marked as exhibit. Just the book number. No. What is the A2? A5? पहले क्या था?
Volume number 1.
एक मिनट पहले क्या हुआ?
Volume number.
A2 A3 तक का ना फर्स्ट जो हुआ था A3 तक का A3 where is the A4?
A4, my lord, the signature of the additional registrar of assurance 3, Kolkata.
Full stop. During her evidence, the signature of the sub-register, seal, number, date have been marked as exhibit A5 to A7. A5 to A7. Full stop. The petitioner also examined the officials of the PS Ranaghat, officer of PS Ranaghat, wherein the GD entry made by the petitioner with regard to loss of the will has been proved, being GD number 1768 dated 23rd of March 2022, and the said report has been marked as Exhibit B. Considering the submission made by the counsel for the petitioner, produced the certified copy of the will, comma, evidence of PW1, PW2, and the PW3, comma, death certificate. This could find that the petitioner has proved the will and is entitled to get the probate. Accordingly, the department is directed to issue probate to the petitioner after compliance of all formalities. At the time of grant of probate, comma, the copy of the will be made as certified copy of the will be made as a part of probate. PLA number so disposed of. Next.
48. I beg to appear, my lord.
Yes.
My lord, this is a will dated, my lord, 31st August 2020 of the deceased, my lord. The son is the executor, my lord. Deceased died with, my lord, living son, daughter, and my lord, widow.
Purushottam Lal Agarwal.
Yes, my lord.
Is the testator?
Yes, my lord.
And where is the name of the executor?
My lord, page 15.
Page 15, 15.
15.
Manish Lal Agarwal. Manish Lal Agarwal.
Yes,
is the executor.
Son.
Is the son.
Son.
Executor.
Yes, ma'am.
So he died on and date of the will 31st of August
Yes.
2020.
2020.
Yes, he died on
Died on, my lord, 22nd May 2021.
22nd May 2021. Legal heirs.
My lord, para 5. Widow, daughter, son. Son is the executor.
Widow, son is executor. 2 daughters.
Consent.
All have given
Consent.
consent.
Consent. All consent.
Affidavit of consent Sulochana.
Sulochana, 2
Affidavit
daughters,
consent of
Rajarshi and Joyasri. Consent is there.
Affidavit of Jayashri. What about the attesting witness?
Attesting witness, my lord, filed
Gautam-
affidavit, my lord.
Gautam Chakravarti?
Yes, my lord. Gautam Chakravarti. Attesting number 2, my lord.
Yes.
And my lord, I must be candid, my lord. The property is also, my lord, in other states of, my lord. In
83?
My lord, I would submit, my lord. My lord, 283 perhaps, my lord. I know my lord's view, but 283 is perhaps is not applicable for our High Court. Why I say, my lord? We commonly say that High Court, my lord, derives jurisdiction under section 300 of the. But, my lord, my respectful submission would be, my lord, 300 is not there in West Bengal. 300 is not there in West Bengal because of the City Civil Codes Amendment Act. Because by the section 22 of the City Civil Codes Amendment, City Civil Codes Act, section 300 has been omitted in West Bengal. And my lord, I
Give the
yes,
succession act. Give the succession act.
Yes. My lord, if my lord 300 is omitted, where from our High Court, my lord, derives power to grant probate.
The High Court
May
will
I-
have the concurrent jurisdiction with the district judge
300.
and exercise or power, except the cases of 57 applies no High Court in
My lord, now এটা দাও এই ফ্ল্যাগটা এইটা আর এরপরে এই ফ্ল্যাগটার পেছনে আছে If now my lord takes up City Civil, I have indicated the relevant portion. This is not a City Civil Codes Act. Section 22. Section 22 says amendment to certain enactments. The enactments specified in the second schedule are hereby amended in their application to West Bengal to the extent and in the manner mentioned in the fourth column of such schedule. Now, my lord, take up the, my lord, I have flagged, my lord, the next page. Year Act is 1925, my lord.
Yes.
Got it. 1925, number 39, Indian Succession Act, 1925. Here, my lord, will find in column 4, section 300 shall be omitted for the state of West Bengal.
Correct.
So, if section 300 is omitted, then, my lord, if we took up the, my lord, 283, the 283 is applicable, my lord, for the power of the district judge or district delegate.
Correct.
And if 300 is available in West Bengal, then High Court comes into play.
No. See, 300 what says?
My lord, power of district judge in all cases, district judge or district delegate may. It is concerning with the district judge or district delegate, not for the High Court. High Court comes into play when 300 is there. If 300 is not there, then High Court will not come under the purview of 283. Why I say, my lord? My lord, if my lord takes up section 273 of the Indian Succession Act.
Section 57, what does section 57 says?
283.
Section 57.
Section 57 says, my lord, the will, my lord, which has been executed within the territories of Lieutenant Governor of Bengal and within the original jurisdiction of Bombay and Madras, that there are certain exceptions with regards to the Schedule 3.
Correct.
And, my lord,
To wills and the codicil made by the Hindu, Buddhist, so and so within the territories which at the said date were subject to the Lieutenant Governor of the Bengal or with the local limits of the ordinary civil jurisdiction of the High Court of Judicial Madras and Bombay.
But this is with regards to the Schedule 3.
Correct.
If, my lord, takes up 213 of the Indian Succession Act, then it requires probate. It requires probate. In other state, my lord, probate is not required. My lord knows, my lord, it is not mandatory. Because only where 200, section 57 applies, my lord, probate of the will is required. My lord, 213. Right as executor or legatee when established. No right as executor or legatee can be established in any court of justice unless a court of competent jurisdiction in India has granted probate of the will under which the right is claimed or has granted letters of administration with the will or with a copy of an authenticated copy of the will. This is subsection 1. Subsection 2 says, my lord, these sections shall not apply in the cases of wills made by Mohammedan or Indian Christian and shall only apply in cases of wills made by Hindu, Buddhist, Sikh or Jain where such will are of classes specified in A and B of section 57. So, section 57 says a person, if he made a will sitting in West Bengal in respect of a property in Bihar, it requires probate.
Naturally.
It requires probate. A person sitting in Bihar in respect of a property, my lord, in West Bengal, whether probate is required or not. In that case also probate is required. So, West Bengal, original jurisdiction of Madras and Bombay are separate class among the amongst the, my lord, total union territory.
Correct.
And, my lord, if my lord takes up 273 of Indian Succession Act, it was a long practice, my lord. This type of, my lord, citation was never issued, but somehow it has now come up. Why it was not issued, I will come that, my lord, on that also. 273, my lord. Yes. Conclusiveness of probate or letters of administration. My lord, got it? Probate or letters of administration shall have effect over all the properties and estate, movable or immovable, of the deceased throughout the state in which the same is or are granted, and shall be conclusive as to the representative title against all debtors of the deceased and all person holding property which belongs to him, and shall afford full indemnity to all debts, paying their debts, and all person delivering up such property to the person to whom such probate or letters of administration have been granted. Now, my lord, first proviso. Provided that, it says, my lord, throughout the state. Then proviso comes. Provided that probates and letters of administration granted by a high court or by a district judge, where the deceased at the time of his death had a fixed place of about situated within the jurisdiction of such judge, and such judge certifies that the value of the property and estate affects beyond the limits of the state does not exceed 10,000 rupees, shall, unless otherwise directed by the grant, have like effect throughout the other state. So, my lord, by virtue of first proviso, probate granted by the High Court shall have an effect throughout the India. And second proviso, that and by virtue of B, district judge only can grant probate in respect of the property situated in district and property value not more than 10,000 outside. And my lord, here the High Court's grant. And my lord will find from the City Civil Courts Act, if my lord now takes up the City Civil Courts Act, that schedule.
Yes.
Schedule 2, my lord, got it? Above 300.
Second schedule.
Yes, second schedule, that page, in that page also. In section 273, clause A of the proviso shall be omitted. Here also, my lord, High Court has been omitted. First proviso, High Court.
Where?
My lord,
Act of the Central Legislature, section 300 shall be omitted.
above that, that is 4, 3 and 2.
Achha.
2.
Section 274 of section 1 of following section, where the probate of letters of administration have been...
My lord, in section 273, clause A of the proviso shall be omitted. My lord, that schedule I have referred that.
The sections 273, clause A of the proviso shall be omitted.
Omitted. Here, my lord, if my lord compare with 273A, first proviso, High Court has been omitted.
High Court.
So, how our High Court grants probate? How it affects throughout the India or West Bengal? Because High Court does not have 300 or 273A. And my lord will find also in the City Civil Courts amendment schedule, in section 274, there are certain amendments also.
Correct.
Regarding the after grant procedure.
Correct.
Here also, my lord, High Court, since High Court has been omitted, my lord, if my lord takes up 274, then it requires, my lord, every High Court to, my lord, transmit the certificate saying that this property in that particular High Court area has been granted by this High Court. This was also not required for our High Court because of the change of this amendment.
Where the probate or letters of administration has or have been granted by the district judge with the effect, we are not concerned on that. The district
That
judge
is also, we are not concerned even, but still,
concerned.
our High Court need not require to send the documents to other High Courts.
Correct.
But in respect of other High Courts, it was required.
Other High Court, we are not concerned.
So, wherefrom our High Court, my lord, absorbs the power to grant probate. Now, my lord, kindly come to my lord, original said rules, my lord, letters patent.
Which chapter?
My lord, letters patent text, page 11 to 33.
Letters patent.
Letters patent. My lord, clause 34.
Yes, testamentary.
Clause 34, the text of the original text of the my lord, letters patent. Testamentary and intestate jurisdiction. And we do further order that the said High Court of Judicature at Fort William in Bengal shall have the like power and authority as that which may now be lawfully exercised by the said High Court in relation to granting of probates of last wills and testaments and letters of administration of the goods, cattle, credits, and all other effects whatsoever of the person dying intestate, whether within or without the Bengal division of presidency of Fort William, provided always. That means by this power, my lord, High Court has the power within or, my lord, outside the Bengal. That nothing in this letters patent content shall interfere with the provisions of any law which has been made by the competent legislative authority of India, by which power is given to any other court to grant such probates and letters of administration. Here, my lord, 7 except our High Court, no other court has been granted
No power to
grant probate in respect of properties in other state. And thereafter, my lord, if my lord takes up chapter 35, the entire procedure has been, my lord, described in the manner how a probate to be granted. Probate or letters of administration. My lord will find section 4, clause 4 of chapter 35.
Chapter 35.
Clause 4.
Clause 4.
Application for probate or letters of administration or certificate. These are the documents required to be filed along with the probate. This was not, my lord, this is, my lord, in addition to the, my lord, what says in the Indian succession. We have this special procedure.
Certificate or register as to duty.
These are the procedure.
Yes.
The specific form and everything has been provided in our, my lord, original set rules.
Correct.
And now, my lord, it takes up 5A, small a. In all applications for probate or letters of administration with the will annexed, the petition shall state the names of the members of the family or other relatives upon whom the estate would have devolved in case of an intestacy, together with their present place of residence, which we do. Our legal heirs column we do. And my lord, now come to my lord, 9, clause 9.
Citation.
Citation to rightful parties. On an application for letters of administration, unless otherwise ordered, a citation shall issue to all persons having a right to take the grant prior or equal to that of the applicant, unless such person have signifies their consent to the application. Here, my lord, our procedure is, if consent grants, it is non-contentious business, and probate grants in a common form. In no other code, my lord, will find, or the subordinate code will find this procedure has been followed. Everywhere publication and everything is required. So our High Court, by virtue of letters patent, holds a unique power, which is not.
That's correct. See.
And my lord will find how the grants, my lord, because of my lord 273 first proviso A is also omitted, how the grants affect. My lord, kindly come to rule 13, clause 13 of that chapter. Here, my lord, grants limited to state of West Bengal. All grants of probate or letters of administration with or without the will annexed, other than grants under the Administrator General's Act, shall, unless otherwise ordered, be drawn up by the registrar with effect within the state of. By virtue of this, my lord, power comes to grant, my lord, within West Bengal, and my lord 14, grant throughout India. It says, my lord, in all cases under Indian Succession Act, in which it is sought to obtain a grant of probate or letters of administration with or without will annexed to have effect throughout Union of India or under Administrator General's Act with effect throughout any or all the states other than the state of West Bengal, such grant must be expressly asked for and it must be shown thereof where the assets are situated. My lord, we disclose in the affidavit of assets where assets are situated, and in the prayer we also pray kindly grant issue throughout the my lord India.
Correct.
And my lord, E takes up section clause 33, practice procedure.
Yes.
In cases not provided by this chapter or by the rules of procedure laid down in the Indian Succession Act. Here, my lord, if it is not, my lord, not provided in this chapter, then, my lord, Indian Succession Act will come into play. Here, my lord, specific provisions are there, rules are there, how citations to be made and to whom the citations to be made. And our High Court has power to grant issue throughout the state of, throughout the India.
That's correct. That's correct. Okay, it is. There is no
And,
dispute.
and
with-
another thing, my lord, if my lord takes my lord chapter 40, and my lord, let me complete first, my lord, 33. Or the in cases not provided by this chapter or by the rules procedure laid down in the Indian Succession Act or the Administration General's Act or the code means this latest patent, the practice or procedure of the probate division of High Court of Justice in England shall followed so far as they are applicable and not inconsistent with this chapter of the sentence. So England following the practice procedure, it has to be followed. It was a long practice, it was never done before. And my lord, if takes
Still we can follow the England procedure.
Rule says so, my lord.
So then
We
we
cannot.
have to follow the rules of the England and incorporate in
And
that.
this is the no, my lord. Now, my lord takes up the chapter 40. If my lord takes the chapter 40.
How much time will take?
I just completed.
Huh?
I just saw this provision and complete.
40.
40. Rule chapter 40, rule 3. Present practice.
Yes, sir.
It is, my lord, after
Rule 3, yes.
rule 3. Where no other provisions is made by the code or by these rules, the present procedure and practice shall remain force. Present practice means which was present at the time of, my lord, latest patent which comes. And that practice was followed. And
that's correct. My contention is that, okay.
It was not required.
283 is not applicable.
Applicable.
But person has to take in, if it is in the state of UP, state of Jharkhand, state of anywhere. So some
Because, my lord,
procedure is to be adopted.
my lord, because our High Court can grant probate,
Can grant.
And not only that, our High Court need not to send any certificate to other state that saying that we have issued the grant in your state.
Not necessary. No,
So,
that's what I'm telling.
Yes.
I am fully with you. I am not in that the court cannot grant. Court has to issue the certificate to the district judge or to the other state. That is okay. There's
it
no
is not required, our.
That's why there's no problem. But with regard to the property which is situated outside the jurisdiction of this court or outside of the state of the West Bengal, okay, 283 is not. But some precaution is to be taken by the court while granting.
I
Some
understand, my lord.
opportunities to be given the person of the calling.
My lord, our rule says in intestacy, who are the person, we have to name them.
Correct.
We have named them.
Correct.
Either we have to issue citations upon them or they will come and, my lord, give consent.
Correct.
Here, my lord, everything closed. Where if at all it was required for our High Court to issue that, our procedure, our procedure, it could have been written something alike to 83.3. It is not there. If it is not there in our procedure, we, my lord, with my deepest respect, my lord, we have need not to follow any extra procedure which has not been practiced at all in our High Court. This is my lord, it is only for clear my understanding. I know my lord's view. I take my lord, others are waiting, I also there. But my lord, now the things are coming, my lord, this publication, because my lord,
No, that's why, because 283, some of the advocates have mentioned before this court. This court is of the view with regard to 283, notice is not required to give to the district judge because the person address is not appear. How the district judge will cause the notice in the property?
person.
So that's why this court has ordered
for publication.
for publication.
I know that. I know that. I know that. That is why
For the purpose of general, what will happen? If
nobody is no heirs is there in intestacy, who will
yes
come?
is different things. Heirs is
Only the creditor can come.
correct.
Creditor can come. And our rule says, my lord, the creditor can, my lord, if my lord takes our
Do one thing.
Yes,
You come the total a small return notes. Come with that. I will give a sufficient time so that appropriate order can be passed. It will be a for all purpose.
that is direction.
That will be better.
Because my lord, at
Because
least for
then
myself,
it will cause guidelines for to all.
yes, my lord. Because at least so far myself is concerned, my lord, I am practicing in this probate field since 2007.
So that's why I'm
My
telling.
lord, never I have seen or it was required for my lord publication in other state.
No, because of the you or persons are filing an application under 283 for citation.
Somebodies are filing, my lord.
No, in all application which is outside. Whatever
Yes,
the
yes,
cases I
yes,
have
yes,
dealt
yes,
with, nobody has raised the question which you have raised now.
Yes.
And on one of the application, one of the advocate has raised that the citation is not required sent to the 283, 3 is not required. So I have passed the order. Yes, it is not required for the purpose of information of the
yes.
public. The publication is required. This point was not raised.
Yes.
Otherwise, this can also be dealt with that.
Yes. I will try, my lord.
Okay. So appearing for the petitioner, full stop. The counsel for the petitioner has argued at length on the point that section 283 within bracket 3 of the of the Succession Act, 1925 is not applicable in the for this court. Full stop. Due to paucity of time, hearing could not be completed. Accordingly, case is adjourned. Let the matter appear on 30th January 2025 under the same heading at the top as parted, the petitioner is directed to come with the short note of argument.
30th January.
May I only pray for one indulgence? 125. The interim order is expiring. Only 25. Sorry, interim order is expiring to this here in my energy matter. Other side was directed to file affidavit. 25.
Yes, my lord.
My lord, my learned friends are on notice. They are appearing virtually.
I appear for the respondent.
But I'm appearing for the respondent. My lord, kindly give me one more week to file in the affidavit. My lord, kindly limited extension of the interim order. My lord, I cannot oppose that. If it's commences to your lordship.
25.
Commercial.
No appeal preferred.
No appeal preferred, and not only that, my lord, no affidavits also filed.
25. So appearing for the petitioner, so appearing for the respondent. Counsel for the petitioner submit that the interim order granted earlier is going to expire today and paid for extension of the interim order. Full stop. Counsel for the respondents prays for extension of time to file affidavit in opposition. Full stop. Considering the submission made by the counsel for the parties, time to file affidavit in opposition is extended for a further period of how much time? 1 week, 2 weeks?
2 weeks, my lord.
2 weeks. Reply, if any, there to be filed within
1 week thereafter.
1 week thereafter. Full stop. Let the matter appear on 5th of February. No, it is a commercial. 7th of February 2025. Full stop. The interim order granted earlier is extended till 11th of February 2025 or until further order, whichever is earlier.
Grateful.
Very grateful. Very grateful.
Grateful.
Huh?
arising out of another order passed by your lordship in connection with another application. My lord, the Honorable Division Bench initially was pleased to pass an order of 20th of November, my lord, wherein, my lord, the Honorable Division Bench was pleased to grant Bharat Petroleum Corporation liberty, my lord, to file an application seeking deletion of his name. My lord, aggrieved by that order, my lord, my clients, my lord, they preferred a special leave petition. My lord, this was the order of the Honorable Supreme Court, my lord. Honorable Supreme Court, my lord, were pleased to observe, my lord, that the plaintiff is the master of the suit, and my lord, whom he will add or whom he will delete, my lord, is for the plaintiff to decide. Thereafter, my lord, the Honorable Division Bench was pleased to take the matter again, my lord, and lordship will see. So, my lord, though, my lord, there is possibly lordship this matter because of this order of stay. My lord, I have been granted liberty, my lord, to file my affidavit. Affidavit I have filed, but my lord, in view of the last penultimate paragraph, my lord, of that order, my lord, possibly paragraph 7, my lord, at page 3. Possibly my learned friend cannot move this application.
Okay, let's go out of the list.
Go out of the list, my lord, in view of this order of the Honorable.
So appearing for the plaintiff. You are for the
Petitioner, Lordship.
who is for the plaintiff?
My lord, I am for the plaintiff. I am for the. My learned friend is for defendant numbers 1 to 4, petitioner in the review.
No, I am
Oh, sorry, my lord.
so appearing for the plaintiff. So appearing for the defendant number
1 to 4, my lord.
1 to 4 and so 5. BPCL.
BPCL, my lord.
BPCL. Defendant number 5. Full stop. Counsel for the plaintiff has brought the attention of this court to the order passed by the Honorable Division Bench in an appeal being number APOT 338 of 2024 dated 20 November 2024, wherein the Honorable Division Bench, Honorable Appellate Court karo. Have given liberty to the defendant to file an application for deletion of the name in the proceeding. Being agreed with the said order, the plaintiff had preferred an SLP before the Honorable Supreme Court, and the Honorable Supreme Court, by an order dated 2nd December 2024, disposed of the said SLP by holding that if the respondent will file an application for deletion of the name, the said application should be served upon the plaintiff so that the plaintiff can file appropriate reply. And after hearing the parties, the court can pass an order whether it is to be deleted, whether the name of the defendant number 5 is to be deleted or we remain in the suit. Full stop. After the order passed by the Honorable Supreme Court, the Honorable Division Bench, by an order dated 10th of December 2024, has come to the conclusion, has held that the appellant has been able to make out an arguable case on merit, and as such, the further proceeding of the present suit has been stayed. Let the order passed by the Honorable Appellate Court dated 20 November 2024, 10th December 2024, and the order passed by the Honorable Supreme Court dated 2nd December 2024 be kept with the record. In view of the order passed by the Honorable Appellate Court, let the suit go out of the list for the present. Liberty to mention after the disposal of the appeal.
Deeply obliged.
Liberty to mention.
Grateful, Lordship. Only one thing, my lord, there was an affidavit in opposition which I had affirmed. Lordship. Grateful, Lordship. Much obliged.
I appear for the defendant and respondent in the present application. It's an application taken out by the plaintiff in the nature of an Order 38 Rule 5. Lord, in the suit, we have also filed a counterclaim, and we've also taken out an application which is also in support of the counterclaim and Order 38 Rule 5.
Any further thing is required?
My lord, in their application, Lordship had initially directed, my lord, for the bank accounts not to be operated. It was we preferred an appeal. The Honorable Division Bench was pleased to direct us to furnish accounts to them. We have done that after the last day's order. If I may hand over the last day's order.
Appeal disposed of now?
Appeal disposed of. With the direction that we will be giving them and the accounts. We have given that. So this was your Lordship's last order. We have filed the annual report. We have given them a copy. Mr. Shaha was there. My lord, in my application, I am also praying similar reliefs because I also have a money claim.
Where is Mr. Shaha?
This is my affidavit of service.
It's not there. Let pass over.
But may I come back tomorrow then, my lord?
Not today.
It will be Monday, in fact. Grateful.
23. Your Lordship, I am representing the plaintiff, and the plaintiff, this is an undefended suit, and the plaintiff and defendant has amicably settled the issues, and the plaintiff now wants to withdraw this case.
Have you got the instruction? Have you got the written instruction?
Yes, yes. Written instruction means that I have been informed today verbally. So next day, give us the next day. We will provide the affidavit along with both the sides that amicably it has been settled.
So you want the decree should be passed in terms of the settlement and arrive between the parties?
Yes, yes.
Since appearing for the plaintiff, though the matter is fixed today for witness action as undefended suit, but learned counsel for the plaintiff submit that in the meantime the parties have settled the dispute and press for time to fixing the matters to some other date so as to enable the plaintiff to bring the settlement terms of settlement arrive between the parties. In view of the submission made by the counsel for how much time?
Give us, because this is a Horiddar
submission made by the counsel for the plaintiff, the case is adjourned. Let the matter appear on, is a commercial matter?
Yes, 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 Lord.
Let the matter appear on 17th February under the same heading. Next.
24.
None appears on behalf of either of the parties. No accommodation is sought for. Let the matter go. Let the matter be listed in the warning list. Be placed in the warning list.
Gosh.
You are appearing?
24.
Yes, 24.
I'm for the plaintiff.
Take rest, okay. Sit. I will call the subsequent password. Yes, next.
I appear for the plaintiff in this matter.
26
My lord,
for the defendant.
I'm being led by Mr. Deepru Bhattacharya, my lord. He is on legs before the Honorable Alipur
Inspection
Court Raj.
completed.
Yes, my lord.
Yes, my lord.
Foreign inspection completed. Affidavit document. Ready?
My lord, there were directions for affidavit of admission denial
Correct.
and also, my lord, suggested issues.
Is there?
My lord, the affidavit of admission denial, my lord, may I file it?
My lord, I'm praying for a note today, my lord.
Why?
My lord, I'm being led by Mr. Deepru
The
Bhattacharya.
problem. You are the junior. You could bring all the things, and what the senior will do with regard to the admission and denial of the document.
And also, my lord, the suggested issues, my lord, may I hand over? Lordship can.
Commercial suit, this court will not grant any time with regard to the affidavit documents. Sense appearing for the plaintiff. Sense appearing for the defendant. Counsel for the party submit that discovery and inspection of the documents have been completed. Full stop. The defendant has filed the affidavit of admission and denial of the document as well as the suggested issues. Let the same be kept with the record. Counsel for the plaintiff prays for time to file affidavit of admission and denial and the suggested issues. In view of the submission made by the counsel for the plaintiff for the interest of justice, the case adjourned. Let the matter appear on 17th January for framing of issues. February. No, January. For framing of issues. Come ready on that day, otherwise I will close.
My lord, we'll file on the next date.
Grateful, my lord.
Grateful, my lord.
Rajkaria.
I was appearing for the defendant.
26.
My lord, I am led by Mr. Dotto.
26, my lord. I was leading Mr. De, my lord, in that matter.
26.
My lord, the last matter, my lord.
Yes, that is a 17. I have fixed on 17. The plaintiff prays for time.
Very well, my lord. Very.
None appears on behalf of either of the parties. No accommodation is sought for. For the interest of justice, the case is adjourned. Let the matter appear on 21st of January for framing of issues. Yes, next.
28, my lord, I appear for the defendant number 1, 2A, 3 and 4. Now, my lord, 1, 3 and 4 has filed their written statement. My lord, 2A, in the last occasion, there was a direction to file, my lord, the written statement of 2A by 24th December. We have filed it. My lord, only difficulty is that it is my mistake, my lord. The statement of truth was not filed. My lord, I have prepared it, my lord. I am praying for leave to, my lord, file the statement of truth.
Who is for the plaintiff?
Lordship, I appear for the plaintiff. Lordship, no written statement has been served upon us.
Yes, that has not been served.
Why?
Yes, my lord, I am appearing, my lord, on behalf of the plaintiff, my lord. I'm sorry, but I have to appear virtually, my lord. This is a suit for damages. Your lordship will kindly see your lordship's order of 17 December 2024, which is the last order passed in this matter, my lord.
Yes.
In this order, your lordship will find that the same advocate on record, Mr. Shukanto Chakraborty, who was already, my lord, appearing on behalf of defendants number 3 and 4, took upon himself the responsibility to appear also on behalf of the defendant number 2A, the substituted defendant.
Correct.
Yes.
Mr. Banerjee. He is telling that he has already filed a written statement as directed by this court on 24th of December in the department. But he is stating that the statement of truth has not been annexed with the same. So he prays for leave and I will direct to serve the copy to you.
Yes, Milord.
Correct.
And actually, my learned friend Milord also, perhaps he doesn't know, he should also Milord intimate formally that he is appearing on behalf of 2A. That he has to write a letter under Chapter 8 of the original side rules, Milord. He can do that because these things were not there. We were a little confused.
Why you persons are not informing if you entered appearance?
Milord, the thing is that, Milord, as I have not filed the statement of truth, so Milord, after the leave, Milord, I
But you file a wakalatnama. Once
Yes,
you
yes,
file
I
a
have filed the
wakalatnama, immediately you have to inform the other side you are appearing.
Milord, your lordship can give my learned friend some time, maybe a week, within which he can give us a copy of the written statement, Milord, and Milord, direct discovery and inspection of documents.
So appearing for the plaintiff, so appearing for you are appearing for all defendants.
Milord, no, not defendant number 5.
Defendant number
5. Milord, 1, 2A, 3 and 4.
1, 2A, 3 and 4. None appears on behalf of the defendant number 5. Defendant 5. Counsel for the defendant number 2A submits that in terms of the order passed by this court dated 17th December 2024, the defendant number 2A has filed written statement in the department, but inadvertently the statement of truth is not filed along with the written statement and prays for leave to file written statement of truth in the department. In view of the submission made by the counsel for the defendant number 2A, leave is granted to file the statement of truth by Tuesday.
It is ready, Milord, by Monday.
By 14th of January 2025. Full stop. After filing of the statement of truth, the department is done. The department is directed to accept the statement of truth. Full stop. After filing of the statement of truth, the counsel for the defendant number 2A is directed to serve the copy of the written statement to the learned counsel for the plaintiff on the same day. Full stop. As the defendant number 1, 2A, 3 and 4 have filed their written statement accordingly.
Defendant number, all the defendants have
5 also
Yes.
filed. As all
Yes,
the defendants filed the written statement, the parties are directed to complete the discovery and inspection of the document. 3 weeks. Full stop. Affidavit of admission and denial be filed within a week thereafter. Full stop. In the meantime, the parties are also directed to exchange their suggested issues. Release the matter on 18th of February 2025 for framing of issues. Next.
Deeply obliged.
I appear for the plaintiff. Milord, if your lordship takes the last order of 26th November, the writ of summons could not be served. I had sought for directions to take appropriate steps. Milord, we have found that the cost title needs some amendment. The address is not correct. We have taken out a formal application for amendment of the cost title in the plaint. That application is before the master, Milord. I have been told that it will appear any day next week. Your lordship can.
So appearing for the plaintiff. Police counsel for the plaintiff submit that the plaintiff has taken out an interlocutory application for amendment in the cost title of the plaint. In view of the submission made by the counsel for the plaintiff, the case adjourned. Let the matter appear on 28th of January 2025. Next.
Deeply. Milord, item 30. I am for the plaintiff.
That's the defendant.
They have filed their written statement along with the counterclaim. Milord, in this matter, if your lordship recollects, the written statement was filed on the 120th day, then went in appeal and everything. The written statement is along with the counterclaim. We have used our additional written statement, which has been filed and served upon them.
No, but not served, Milord. We have not received any copy.
It has been served on email. I shall give another copy if that is.
When they have filed the written statement?
Milord, on 6th, Milord.
6th of January?
6th of
December, Milord.
December.
Milord, your lordship's last order of 17 December 2024, your lordship had
granted to file additional written.
Yes, 30 days. It was filed within time.
You filed?
Yes, 2nd
Show the
January.
copy.
We'll give a copy. It's in scrutiny or?
Scrutiny is not complete.
My lord, I've been told it is in scrutiny. It is not completed. The scrutiny has not been completed. Yes, we shall.
So-and-so appearing for the plaintiff, so-and-so appearing for the defendant. It is submitted by the counsel for the respective parties that the defendant has already filed written statement along with the counterclaim, and the plaintiff has also filed additional written statement to the counterclaim. The counsel for the defendant submitted they have not received the additional written statement to the counterclaim. Accordingly, the counsel for the plaintiff is directed to serve the copy of the additional written statement to the learned counsel for the defendant within a week from date. Full stop. As the written statements have been completed, accordingly, the parties are directed to complete the discovery and inspection of the document within 3 weeks from date. Full stop.
My lord, maybe 4 weeks.
4 weeks, 4 weeks from date. Full stop. Affidavit of admission and denial of the document. Affidavit admission denial document will file within 2 weeks thereafter. Full stop. In the meantime, the parties are also directed to exchange the suggested issues. Full stop. List the matter on 25th of February 2025 for framing of issues.
My lord, we are also, although that need not be recorded in the order, we are taking out an application for rejection of the counterclaim.
will come in
That 12-way leave point. Lord, that's something. Lord, may my counsel on record be given an opportunity to inspect the plaint once, the original plaint that is on.
As per the prayer made by the counsel for the plaintiff, the advocate on record of the plaintiff is granted liberty to inspect the record of the present.
Lordship, I'm appearing for the plaintiff. Lordship, in this, the plaint was served on the last occasion. My learned friend was appearing virtually, and your Lordship may remember there was a issue that the plaint had been served, but no written statement had been filed. They had taken out a master summon for extension of time to file written statement, but that master summon was never filed. So there is at present no application for extension of time to file written statement.
Your Lordship, I'm sorry that I have to appear from VC only.
Yes.
Your Lordship, in this matter, Your Lordship, I want to apprise the Honorable Court about the facts, Your Lordship. In this matter, I personally came to Calcutta High Court on 22nd of August with my client, Your Lordship. And we had prepared all the WS, GA, everything, VOCA, everything we had prepared and sworn before the Commissioner, Your Lordship. The counsel which we had employed, which we had engaged here, Your Lordship, he told me that he will file the same on the next date through his clerk. On the next date, Your Lordship, from that day onwards, I am asking him what has happened, Your Lordship. I am asking him to give return back by copy, Your Lordship, after last date. Because of the last date of hearing, they had not filed. So I came to know on the last date only that they had not filed. Then I have also asked him to return my brief to me, Your Lordship, so that I can engage another advocate to file the same, Your Lordship. So my only request, Your Lordship, is that the matter be fixed for specially fixed matter.
When the writ of summons was served?
29th of April 2024. Your Lordship, they had affirmed an affidavit.
There is an order of the independent suit.
No, Your Lordship. It had come up for the. My Lord.
When the writ of summons was served?
29th of May.
So have you obtained report?
Your Lordship, the report was a little cryptic. It could not be made out because the Saket court had not given back the date on which the summon was served. So by then, my learned friends had appeared and had sent an application by which they wanted to have the time.
That's why. What is the application?
Your Lordship, this application is for extension, but it was not filed. It is not numbered.
When the notice was issued to you?
Your Lordship, the date of dispatch was, as per this, the 4th of...
Communication made by one learned advocate Hariram Singh to the plaintiff on 10th of September.
Your Lordship, 10th of September.
This one.
Yes, Your Lordship.
How you came to know 10th September?
Your Lordship, I do not want to hand out again. Your Lordship's name is misspelled here.
When you receive the writ of summons, sir?
Your Lordship, on 29th of April, Your Lordship.
Huh?
29th of April. 29th of
29th
April.
of February 2024.
April, sir, April.
29th of
Please, Your
April.
Lordship. 24.
But you have not filed the written statement.
Your Lordship, I came to Calcutta High Court on 22nd of August.
Okay, when your application will come, we'll see to that.
Your Lordship, my only submission is that the matter will be fixed for 7th of February, specially fixed matter. I will personally come to Calcutta and engage another
Nothing
advocate.
will happen. Either you come on 7th because you have received on 24th for 29th of April.
Yes, sir.
When
Your
you
Lordship, the matter...
29th April.
Please, Your Lordship.
So-
Thereafter, I served the advance copy to them also.
Your Lordship, the matter was fixed today
I
also.
had served the advance copy, Your Lordship.
Suffering for the plaintiff.
I had served the advance copy also, Your
Suffering for
Lordship.
the defendant. So the counsel for the defendant submit that the writ of summons was served upon the defendant on 29th of April 2024. And accordingly, now the defendant has taken out a master summons for extension of time to file written statement. But till date, the master summons is not on board. Full stop. This court find that the writ, it is admitted by the learned counsel for the defendant that the writ of summons was served upon the defendant on 29th of April 2024. Admittedly, the suit is of the commercial
There's only one thing I have to say.
in nature. Thus, the time to file written statement by the defendant is over, and thus 120 days, that is the outer time for filing of the written statement, has been completed, but till date no statement is on record. In view of the
There's only one thing.
Yes, Com 12 of 2024 be placed in the list of undefended suit. Full stop.
There is only one thing I would like to say.
Plaintiff is directed to file the plaintiff is directed to file the judge's brief of document within 2 weeks from date. Full stop. Affidavit of evidence of the plaintiff witness be filed within a week thereafter. Full stop. List the matter. Give the date.
There is only one thing I will explain, Jordan. Only
List
one
the
thing I will
matter.
explain.
6th March 2025 at 3 p.m. for witness action. Yes.
There is only one thing. There is only one thing. Only one thing. My submission has been copied on you. I had served the copy of the written statement to the other counsel through email. But as per the format of Delhi High Court, I had served the copy to the
Correct. When your application will come for hearing, we'll see to that, sir. At present, there is no written statement on record. Service of copy will not serve. As per the law.
But the kindly format statement also, Your Lordship.
Correct. You come with the application, the court will consider that. Yes.
Kindly
Next.
format statement to that extent. Kindly format statement to that extent, Your Lordship.
Yes. No problem. Yes. Next.
My lord, in this matter, my lord, I appear on behalf of the defendant. My lord, on the last occasion, I had pointed out, my lord, the defendant, my lord, has been admitted under Section 7 proceedings of the IBC, my lord. I had handed out a copy of the order passed by the learned National Company Laws Appellate Tribunal.
Defendant.
I am for the defendant. As per my lord's direction on the last occasion, my lord, I had effected the service of the order upon the plaintiff also. My lord, here's the record of such service.
Yes. What will happen?
Your Lordship, the matter is still pending admission in NCLT.
How the suit can proceed?
Exactly, my lord. I was
Lordship,
beseeching
grant
lordship.
time till...
What? For what? If it is before
Lodge
the
a claim before the
if it is
NCLT.
before the
It has
NCLT,
been-
either two-way, either I will
We can
dismiss.
lodge a claim before the NCLT, but Your Lordship, the NCLT has not yet, we are informed that NCLT has not yet
My
admitted
lord,
the
they have
CRP.
been informed, but they cannot go beyond this order, my lord. This order dates back to 27th November 2020.
This order is of the NCLAT, which
So,
orders the
kindly
NCLT to...
Kindly read this portion. What has been stated? The adjudicating authority may pass an order admitting the Section 7 application within a period of 1 month from the date.
Yes,
You
exactly.
have been given the liberty to approach the NCLT. my lord, we had effected the service of this order upon them, my
Lordship,
lord, on
please
7th
grant-
January.
So appearing for the defendant.
Your Lordship, if you look at the order,
Counsel for the defendant submit that the defendant has gone into CIRP. In view of
Your
the-
Lordship, the
and the
order of CIRP has not been.
He has already passed an order directing the authority to admit the defendant in the CIRP.
Your Lordship kindly grants us some time to
In view of the
produce
above, let
the.
the matter go out of the list for the present, liberty to mention.
My lord, this has been served upon them. My lord, I was still beseeching your lordship
Go
to
out of the
dismiss
lab-
the suit, my lord.
Let it go out of the list.
Because this way, my lord, there will be pendency of proceedings here as well as
can be
before the
done?
NCLT. They
Your
might just go
Lordship,
before the
NCLT is waiting if there is a settlement between the parties there.
My lord,
the
how is it
CIRP
so to
admission will
happen, my
not
lord?
take
How the
place.
suit can proceed?
Your
How
Lordship
is it
grants
so
us
to
some time.
happen, my lord?
Produce the application for dismissal. I will see.
I'll produce the order dated 12th
See,
December
either
and
the
6th
suit is to
January.
be stayed, the court cannot restate.
Exactly, my lord.
Suit is
So
to
that
be
is
stayed,
what I
so
was
am
beseeching, my
citing.
lord. The suit cannot be proceeded with
So that's
under
why
any
you let it
circumstance.
go out of the list. What you
Number 33.
Wait, please, Your Lordship. My lord, I appear on behalf of the plaintiff in this matter.
For the defendant, my lord.
Yes, my lord, as indicated on the last occasion, there are 3 applications pending, Your Lordship. GA number 3 is their application, Your Lordship. For
3 and 4, my lord, is
Three.
my application, my lord.
Yes.
Defendant's application, my lord. One is for rejection and return of plaint, my lord, on the ground that this is not a commercial dispute, my lord. Squarely covered, my lord. 106 notice, my lord. 106
Now, my lord,
notice. It's not a commercial dispute. And my lord, one application, my lord, for extension of time to file the written statement, my lord.
And what is the 3?
GA3 is my lord, their order 7 rule 11 application. GA4 is my lord, as my lord, my learned senior friend has stated, their filing of the extension of the written statement.
What
And
is 5?
GA5 is my application, my lord, seeking reliefs for towards direction upon the defendants to pay certain sum of money in terms of the occupational charges.
My lord,
Now, my lord,
that we are already
that
paying
yes,
in
your
terms
lordship.
of the
That has
order of
already been complied with, your lordship. That is still going on, your lordship. My lord, they have on the last occasion filed their opposition to GA5, my lord, my application. Liberty was given to us to file the reply. My lord, I would be humbly seeking 1 week's time, my lord, to file the reply. In the meantime, if your lordship kindly fixes any date.
Of which?
All the applications can be heard out, your lordship. Any date could
So
be
in
fixed,
which
your
you wanted to file reply?
lordship. GA5.
And other are completed.
Pleadings are complete. Extensive arguments have been made, my lord, before the coordinate bench as well, your lordship. But since it has determined after changing of determination, my lord has to hear. My lord, may I fix any date, my lord? It will require some time, your lordship.
Since appearing for the plaintiff, since appearing for the defendant, counsel for the respective parties submitted. Pleading in respect of GA3 and GA4 is completed. Full stop. Counsel for the plaintiff submission prays for extension of time to file affidavit in reply in connection with GA5 of 2023. Let affidavit in reply be filed within 2 weeks.
1 week.
Within 1 week from date, list the matter along with all interrogatory application on 11th February.
My lord, only one thing, my lord. For my lord GA4, my lord, there was already an order for going out of the list because, my lord, if in case it is held that this is not a commercial dispute, my lord, then this 120 days will not apply, my lord, on that.
That's why all the application come on that day.
Deeply obliged.
Your Lordship, 34 and 35, Your Lordship, are connected matters, Your Lordship. Your Lordship, this is a change brief. Therefore, I'm requiring certain time to get all the documents and take steps in the department. So, therefore, if Your Lordship could kindly adjourn the matter for a period of 2 to 3 weeks, I'd be extremely grateful, Your Lordship.
Which one?
33 and 34 and 35, item 34 and 35.
34, 35.
I prefer the plaintiffs, Your Lordship.
Yes, what required? Why adjournment?
Your Lordship, I don't have all the documents with regard to the matter, Your Lordship. Your Lordship, it's a change brief, Your Lordship. Therefore, from the previous advocate on record, I haven't received all the documents as yet, Your Lordship. In that regard, I'm praying for an adjournment so that I can get all the papers. I can take the steps in the department and appear in the
But
matter.
only you wanted to proceed with because preliminary degree already passed. Preliminary decree already passed. Only you wanted to proceed with the interest. You filed a review application for claiming interest. This court has held that
Lordship,
no interest cannot be.
it is only in respect of that. We just received the paper, some of the papers yesterday.
So this is a commercial suit, sir. This will
Lordship, may allow me some time and I will endeavor to have everything completed.
every time one advocate will come, it is a change brief.
It has been changed, Your Lordship, on the last occasion. The erstwhile advocate did appear.
December 6th, you are
December
appeared.
6th. I did not appear. The erstwhile advocate appeared, Your Lordship.
What is your good name?
Siddharth Basu.
Shovikre, who is the Shovikre?
He was the erstwhile advocate record.
Plaintiff submit the plaintiff intend to proceed with the matter with respect of the claim of interest. Only the interest claim. What remains?
Yes, Your Lordship. I believe we have been informed. We
The
take
review
out an
application
application.
is also dismissed. Both are the same.
34 and 35.
Sense appearing for the plaintiff, sense none appears on behalf of the defendant. Counsel for the plaintiff submitted. This is a change brief and requires some time. In view of the submission made by the counsel for the plaintiff, the case is adjourned. Let the matter appear on 25th of February. Next.
Grateful.
34, 35. Hmm? 36.
My lord, I am appearing for the plaintiff in this matter.
Hmm.
My lord, sadly, after filing of the suit, the defendant closed all its office within the jurisdiction and ran away.
Well,
And we are not able to trace where from he is operating right now. Can't effect service or summons, my lord.
But wrongly it is appearing. It is 7th February. Last order you have gone through? You have not gone through the last order? 7th February. Come on, 7th.
Much obliged. Meanwhile, we will try to take steps to find out.
Yes. Why it is appearing? 20 January.
Yes, madam. Grateful, madam.
Item number 38, my lord, I am for the defendant, my lord.
Yes.
And 39, I am for the plaintiff, my lord. My lord, these two suits, my lord, we have principally agreed, my lord, to refer the matter to the arbitrator, my lord, under section 89. It's only the consent agreement, my lord, that has not been signed by the parties, my lord. My lord, by next Friday, we shall file it, my lord, before your lordship, my lord. Your lordship can take it up on next Friday, my lord.
For sending to the arbitrator?
For sending to, my lord, there were two sets of matches. One has already been referred. Arbitration is going on, my lord. And my lord, this was pending, my lord. My lord, we have to file the written agreement, my lord. So by Friday, we shall file. My lord, we will take it up next Friday, my lord. Both the suits.
As per the prayer made by the counsel for the plaintiff, suffering for the plaintiff, as per the prayer made by the counsel for the plaintiff, the case adjourned. Let the matter appear within a week.
Next Friday also, my lord.
Let the matter appear on 21st.
Deeply applied, my lord.
Item 40, I beg to appear for the plaintiff, my lord.
Yes.
Undefended suit, my lord, by an unpaid seller for, my lord, the unpaid amount of goods sold and delivered. The evidence was concluded, my lord, on the last.
Evidence over?
Yes, my lord.
Evidence closed?
Yes, my lord. Evidence closed, my lord.
Today's further evidence.
I beg your lordship.
Undefended suit or defended?
Undefended.
Undefended
suit, my lord. Money is already deposited and, my lord, as a security. It's, my lord, for a sum of.
The defendant appeared?
Defendant appeared for cross-examination, my lord. But, my lord, today I don't see the defendant appearing. But, my lord, I may be permitted to begin, if your lordship so pleases.
Yes.
My lord, the prayer in the plaint, my lord, is at page 6.
Yes.
My lord, decree for a sum of rupees 18,50,257 and 58 paise.
Correct.
My lord, this is for paragraph 10, my lord. It's the calculation in particulars are there.
42 lakhs. Part payment paid, 25
Yes, 25 lakhs part payment paid. Amount due is this.
Remaining
and
17 lakhs.
17,24,400.
Interest 1,25,000.
Yes,
So
my lord.
total 18 lakhs.
Yes, my lord.
Okay, then.
My lord, in this matter.
How the amount is required to be paid by the defendant?
Yes, my lord. I'll indicate.
What
My
is
lord,
the contact between you?
My lord, the purchase order from the judge's brief of documents, if your lordships has. page 7. Page 7 of the judge's brief of documents, my lord, is the purchase order dated. Your lordships has page 7.
Yes.
But it's the purchase order issued by the defendant, which is at the top left, my lord, APL Metals Limited, for, my lord, delivery of lead. And, my lord, the rate is there, and the final amount, my lord, is 40.
What is the delivery of lead?
For lead ingots, my lord. And, my lord, the quantity is indicated to be about 20 metric tons. And the rate per metric ton is
20 hai?
20, my lord, 20
Only
point,
20 hai?
20 metric tons.
20 metric.
20.000. But 20 metric tons, the rate is indicated as 1,79,000 per metric ton. And thereafter, my lord, the final amount is there. Thereafter, my lord, the material was supplied. The next page, if your lordship turns to the next page 8, is the invoice. I'll indicate how the material was delivered. Page 8, your lordship will find is the invoice dated 28th of November 2021. At the top left, your lordship will find the plaintiff. Not the plaintiff is a proprietorship firm. So A1 Enterprises, buyer is APL Metals, and my lord, the quantity is indicated to be 20,220 kilograms. That comes to 20.220 metric tons. The rate per kg is indicated, my lord, on page 7 was per metric ton, this per kg. The total amount comes to 40.
So you have given 20.20.
20.22.
That is the kg.
That is kg, yes, my lord. And my lord,
this 20,220 kg.
Yes, my lord. On the previous page, you also found it was 20 metric ton, my lord. This approximately 20 metric ton. The final amount is there at 42 lakh rupees, 70,868. On the page thereafter, my lord, is the delivery, my lord, the challan, which was, my lord, what I had supplied was perhaps in the photocopy was not clear. On the page following that is a clearer copy. May have a challan which has, my lord, a better copy. Page, my lord, 9. And my lord, page 9 I had supplied a clearer copy to your lordships.
It is exhibited?
Exhibited.
What is the exhibit?
My lord, exhibit. My lord, it was marked X. Because, my lord, in this case, my witness could not, my lord, he was not present physically at that time. So, my lord, the challan was marked X for identification. But anyway, my lord, I'll indicate how the delivery and acceptance of the material has been admitted. And my lord, on an earlier occasion, when we had filed an application for judgment upon admission, your lordships had passed an order wherein, my lord, it was found that the delivery and acceptance of the goods was recorded. And thereafter, my lord, the defendant was directed to deposit the amount. So, my lord, the delivery and acceptance is, my lord, no longer in question in this case. But on the following page, page 10 is the e-way bill. Again, my lord, only for completeness, the e-way bill is also there, has been proven by my witness. E-way bill has been, my lord, marked in evidence. That is exhibit E.
Then?
So, my lord, the delivery is done by way of road transport. The e-way bill is there, challan is there. And, my lord, in the invoice, my lord, I missed out on that. Page 8, your lordships will find that the stamp of the defendant is also there. APL Metals Limited, and the date, signature and date is the 28th November 2021.
Yes. This is the invoice they have received.
Invoice they have received. Thereafter, my lord, the part payment at page 12 of the brief of documents, your lordship will find the second last entry. This is my client's, my lord, bank statement.
What is the page?
Page 12 of the brief of documents. That is my client's, my lord, bank statement. At the second last entry, 24th of December 2021, you will find an entry of 25 lakh rupees. This, my lord, is a part payment. In the entry, you will find it is by RTGS, and in the next line, the name of the defendant appears, APL Metals Limited. Your lordship has that. So, my lord, this is the part payment of 25 lakh rupees as against the invoice amount of 42,70,868. Thereafter, my lord, on the next page, very important, page 14, is the email of the defendant's employee. You'll actually find the email is to my client A1, my lord, you will find from nishant@aplgroupco.com. And it is to *aditi@yahoo.in. This, my lord, in the cross examination also, my my lord, witness has proven that this is an email address used by the plaintiff. And my lord, this was on the right hand side of that page. You will find the ledger which is of the defendant, APL Metals Limited, issued to my client. And my lord, at the bottom of that page, you also will find the amount of 17,67,248 appearing.
Due. Closing
Yes.
balance.
Closing balance.
This is due.
This is due against the invoice.
Yes.
And on the page thereafter, my lord,
Yes.
is my client's account confirmation. It is, my lord, on the top left, you'll actually find to APL Metals Limited, and on the right is from A1 Enterprises. My lord, this confirmation of accounts, at the bottom right, you'll also find a closing balance of 17,67,248. So, my lord, this is also signed by the representative of the defendant and my client's, my lord, proprietress. And, my lord, thereafter, following page, I'm only indicating, my lord, the evidence that I have. On the following page is the TDS certificate, TDS, my lord, statement of my client, wherein you'll also find the name of my client, the plaintiff herein, Mamta Jaiswal, at the top of the page. But after the PAN number is the name of the assessee.
Yes.
And, my lord, of the table, first entry is APL Metals Limited. And, my lord, the first entry, serial number 1, the transaction date is 30th November 2021.
Yes.
Date of booking is 31st January 2022. And, very important, the next column, amount paid / credited. This amount is 36,19,380. This, my lord, from the tax invoice at page 8 of your lordship's brief, my lord, the amount before tax will be matching. Page 8. Page 8. 36,19,380.
Okay.
So, my lord, page 16 shows the same amount. Therefore, my lord, this is the entry relating to my invoice. And the tax has been deducted. This is by APL Metals, as I indicated, my lord. The name of the deductor is APL Metals. Your lordship has seen that. Then, my lord, finally, my lord, these goods are subject to goods and services tax. At page 18 is my client's GST portal. Page 18.
Yes.
But this is, my lord, at the top of the page, goods and services tax at the top in the small lettering, goods and service tax GST user dashboard. And here, my lord, my client's name is indicated, legal name Mamta Jaiswal, GST number is there. Trade name is also there, my lord. You'll also find trade name on the top right.
A1.
A1 Enterprises. And my invoice number is indicated. Before that, my lord, processed records APL Metals Limited. And the GST number of the defendant is there. Then, my lord, the invoice date is there, 20th November. Your lordship had seen page 8, same date is there. And the total taxable amount is again 36,19,380. And the total invoice amount is 42,70,868. But identical as page 8.
So what is the tax paid?
Tax paid, my lord, is there. Central tax on the third last column. Central tax is 3,25,744. And state tax is the same amount, 325,744. Again, my lord, may see page 8. Same amount is indicated, 9% of CGST and 9% of SGST. Page 8.
Yes.
325,744. So, my lord, the GST has also been paid by my client, is appearing in the GST portal.
Yes. Yes.
So, my lord, by these documents, I have proven that, my lord, the delivery of the goods, anyway, my lord, I'll show the order of your lordships, where the delivery and acceptance of the goods has been recorded. Here, I've shown that the invoice has been delivered to the defendant. The TDS has been deducted by the defendant. The account statement is there from the defendant's email to my client. And, my lord, the GST has also been paid by my client. Now, my lord, if your lordship takes the order of 23rd August 2023,
23rd August.
23rd August 2023.
ऑर्डर क्यों नहीं रहता फाइल में? 23rd अगस्त सही में?
अरे तो देखिए apologize, my lord, I don't have a hard copy of the order.
Yes.
My lord, this was an order passed in GA1, which was my client's application, my lord, for judgment upon admission. My lord, if I may read the order, in a suit for recovery of unpaid price of goods sold and delivered, this application
What
entirely.
has happened in this order?
My lord, in this order, page 4, if your lordships come straight away, page 3. Page 3. My lord, I am reading in this second paragraph, my lord, about 8th line from the bottom, the balance confirmation, therefore, according to the defendant, does not fasten any liability on the defendant for suffering a decree on judgment on admission. The defendant also relies on paragraph 8, wherein the never mind, my lord. Next page, page 4. After hearing the parties and considering the materials on record, I find that the delivery of the goods are established. Following the provision of Section 42 of the Sale of Goods Act 1930, and in particular, no contemporaneous document from the side of the defendant that the goods are of inferior quality being produced, the goods in question are deemed to have been accepted by the defendant. Once the goods are accepted, the plaintiff for delay in making payment becomes entitled to interest under the provision of Section 61 of the Sale of Goods Act 1930 as and by way of compensation from the defendant. In the instant case, the argument on behalf of the defendant that there is no admission per se from the side of the defendant in respect of outstanding amount or a part of thereof has substance as receipt of invoice or acceptance of the goods or deduction of TDS does not qualify as to admission. It can only be construed as admission of receipt of the goods and its acceptance for which the defendant is liable to pay as per the price quoted in the purchase order issued by the defendant. Then, my lord, at the bottom, my lord, I am not inclined to pass any decree on admission, although the receipt and acceptance does not persuade the court to pass a decree on admission, but at the same time, it cannot be lost track of this of the fact that the suit has been instituted in the commercial division arising out of a commercial dispute. Therefore, my lord, the plaintiff's interest is required to be protected to strike a balance in allowing the defendant to go to trial by securing the unpaid price.
Yes.
Then, my lord, I find
the
that
amount is deposited.
The amount is deposited.
Okay.
17,67,248.
Yes. Then,
my lord, I have in trial, my lord, I've proven the documents. Very important, my lord. I had filed 2 affidavits under Section 65B of the Indian Evidence Act because, my lord, I've relied on 3 documents that are digital documents. One is the email by way of which I have shown that the purchase order was also confirmed by the defendant. Then, my lord, an email from the defendant sending the ledger balance. And then, my lord, the GST, my lord, portal printout. So, my lord, the first affidavit under 65B is, my lord, dated 8th August 2024. Where, my lord, I have proven the email address and the email that was received with the purchase order. And, my lord, I'll indicate that even in the cross-examination, the witness has confirmed that this email address is of the plaintiff and, my lord, operated by the defendant, by the plaintiff. Apologies, my lord. And then, my lord, the next affidavit at paragraph 3, I've proven the TDS certificate which I've printed from the TDS portal, from the income tax portal.
So that's all.
My lord, that is, my lord, one more submission. Your lordship said, my lord, the other side had also objected to this affidavit being under the Indian Evidence Act in view of the Bharatiya Sakshya Adhiniyam coming into force. But I am relying on section 170 of the BNS, which says, if I may read section 170.
Bharatiya Nyaya Sanhita. BNS or BSS?
BSA, sorry, my lord.
That's right.
Bharatiya Sakshya Adhiniyam. I apologize,
Give
my
that.
lord.
First.
Section 170, 170.
Repeal and saving.
Yes, my lord. Subsection 2. Notwithstanding such repeal, if immediately before the date on which this adhiniyam comes into force, there is an application, trial, inquiry, investigation, proceeding or appeal pending, then such trial, inquiry, investigation, proceeding or appeal shall be dealt with under the provision of the Indian Evidence Act as in force immediately before such commencement as if this adhiniyam had not come into force.
Yes.
And my lord, in this case, my lord, the adhiniyam came into force in July 2024. The trial had begun prior to that, my lord, in April. My lord, these are my humble submissions. My lord, the prayer, my lord, I've indicated is for the unpaid price and is also, my lord, for interest under section 61 of the Sale of Goods Act.
Yes.
My lord, the my lord, prayer is at page 6. That, my lord, I've indicated. Prayer is for the unpaid price, which, my lord, is 17,67,248, and thereafter, my lord, interest on such amount. And my lord, interest, if I may place section 61, sorry.
So what is the principal amount?
Principal amount is, my lord, is indicated paragraph 10,
72.
page 4. 17,24,400.
Okay.
And thereafter, my lord, my lord, the amount is secured and then, my lord, interest on the amount. Section 61 I have already, my lord, placed from the, my lord, 23rd August order.
Okay.
Grateful.
Census and suffering for the plaintiff. None appears on behalf of the defendant. Counsel for the plaintiff has concluded his argument. CAV.
Grateful.
Item number 3 and 4 of the non-commercial.
What's the here?
alarm. এইটা রেখে দেন, এটা আমার লাগবে। তোমরাই তো মোটামুটি বলে তো রেডি করে Let me I appear for
affidavit আমরা file করছি, আছে কি
Oh,
we had concluded our submission.
But may I just use a supplementary affidavit? Lord, this is only a compilation of not the requisite documents, Lord, which is the subject matter of not the present suit. A copy দিয়েছো? Copy দিও। যেটা তোমার revocation আছে আর agreement আছে, ওই 4-5টা document আছে। দেখে না? Soft copy
What has happened to the appeal? Appeal is pending.
No, my lord, the appeal is pending, my lord. Told my lord, the appeal is pending, my lord. My lord, it was directed to be listed on a hearing on 24th June, my lord. It is yet to come.
24th June of this year.
Last year.
Thereafter pending.
It's pending. Lord, your lordship has a copy of, my lord, the order of the appeal court.
That is weird.
Have a copy.
Yes.
Now, my lord, the GA1 has been taken out by my learned friend, the plaintiff, my lord, praying for injunction of the nature that your lordship will find, my lord, in the prayers to the application. Now, my lord, your lordship will first, my lord, take the, my lord, the application to see, my lord, the nature of the prayers that they are asking for. Now, my lord, that is at page 29.
Yes.
Number page 29, an order of injunction be made restraining the respondent either by itself or through its main agent servants from relying on the said purported deed of revocation dated May 11, 2021 of the power of attorney dated November 21, 2011. Number they are questioning blood and seeking an injunction on the revocation. An order of injunction be made restraining the respondent either by itself or through its main agents, servants or agents from making any representation of any nature whatsoever to any person or authority on the basis of the said purported deed of revocation dated May 11 such and such. But then the order of injunction restraining the respondent, its main agents and servants from taking any steps for cancelling or from purporting to cancel the irrevocable power of attorney dated May 15, 2021. But I'll come one by one, blood, the documents, blood, what my learned friend is seeking, blood, an injunction on. That is, those documents are contained in the supplementary affidavit.
Yes.
Eventually, blood, my argument will be, blood, if they are blood basing their suit on blood 202 of the Contract Act, they have to show that blood that the power of attorney was granted was coupled with interest.
Correct.
But eventually, I'll be coming to that. If they cannot show, and if I had the right reserve to cancel the power of attorney, and I have done so, they have no case at all. An order of injunction be passed restraining the respondent, its men, agents, and servants from interfering in any manner whatsoever with the rights of the petitioner number 1 to pursue the legal proceeding through the petitioner number 2 and 3 pending and or relating to or in connection with requisition of the portion of the said property, and to receive compensation therefore, including operating bank accounts of the respondent only restricted to such purpose. Number of this, blood prayer number A is directly blood connected with blood the nature of the suit that they have filed. That your lordship will find blood in the plain. Blood, I'll just blood in my lord's order. Your lordship has also recorded that. What was the prayer in not this particular suit? Number prayer A is a decree for delivery up and cancellation of the purported deed of revocation dated May 11, 2021 of the power of attorney dated November 21, 2011 upon adjudging the same to be void. A decree of perpetual injunction restraining the defendant from in any manner relying on the said purported deed of revocation dated such and such of the power of attorney dated such and such and from making any representation on the basis thereof. Thereafter injunction, receiver, attachment. So, the principal prayers are two prayers here. Cancellation of the purported deed of revocation and perpetual injunction. Whereas, the prayers in the injunction application are going beyond what the prayers are there in the plaint.
Yeah.
Therefore, this is not in aid of the interim relief fully. Now, my lord, if your lordship kindly takes up the supplementary affidavit, it is easier to handle, my lord, all the documents. I'll relate, my lord, with the pages in the main application.
Yes.
Now, my lord, to give a brief background, your lordship may remember, my lord, pursuant to order passed by this honorable court on a suit for specific performance, my lord, there was a compromise. On the basis of the compromise, my lord, there was a sale deed, my lord, executed in favor of my learned friend's client, my lord, who was the director at that point of time. Thereafter, my lord, he sold his right in the property of my client, that is Punalur. And my lord, that there are certain other power of attorneys, my lord, executed pursuant to an agreement. This agreement was, my lord, after the sale was, my lord, done on 2003. It was in 2010.
Yes.
Now, my lord, the 2010 power of the agreement, my lord, I'll just take your lordship to page 7 and thereafter, my lord, the clauses thereafter. To understand, my lord, what was the scope of this agreement.
Yes.
And, my lord, whether, my lord, that the power of attorneys and the revocation thereof, the power of attorney, my lord, granted was, my lord, for, my lord, whether any property rights were vested upon them or not. Now, my lord, at page 12, internal page 5, the undermentioned various legal proceedings and litigation were pending by or on behalf of Punalur challenging the acquisition and requisition for recovery of compensation, profit and other relief from the said property. Now, my lord, the number of cases, my lord, that has been, my lord, stated out here. The above several legal cases and or proceedings are hereinafter collectively referred to as litigation. Then, my lord, internal page 6, page 13, Lindsay had purchased the said property from Punalur by virtue of registered conveyance deed in book number such and such dated 5th April 2003. And the same on the understanding that the Lindsay shall at all time be entitled to continue, prosecute and or defend all or any of the said litigations and or proceeding thereunder, and also to receive, realize and recover all compensation, mean profit issues and profits on account and in respect of the portions of the said property which have been the subject matter of the said litigation in the name of Punalur, but at its own cost. Therefore, my lord, this is a creation of an agency, my lord, an agreement for creation of an agency. In pursuance of the understanding as herein before stated, Lindsay has so far been taking appropriate steps for realization of the compensation amount and mean profit, and also continuing to pursue and prosecute the said litigation and the proceeding thereunder in respect of the portions of the said property in the name of Punalur, but at its own cost. Then, Lord, the next page, page 14, internal page 7, Lord, clause 2, last 3 lines, and also taking appropriate steps for realizing, recovering compensation amount and mean profit from the appropriate requisitioning and or acquisitioning authorities, and the same in the name of Punalur. Now, Lord, this is an agreement which is post-sale agreement.
When the sale was
2000, that was 5th of April 2003. And this is dated 2010,
15th May.
15th May.
Yes.
Now, clause 5, last 2 lines. In the name of the company for limited purpose of receiving, realizing and encashing the amounts of compensation, mean profit and other amounts as may hereinafter be received and realized on account and in respect of the portions of the said property. Then clause 6, last line, on behalf on account of the Punalur. Name and on behalf on account of Punalur. On account of Punalur. That is important, this particular phrase.
In the name and on behalf of.
On behalf of
Kunal.
and on account.
Yes, in the name on behalf of account on Pularu.
Not on account of Lindsay.
Correct. On account of
Or
Kunal.
Punalu. Then, my lord, your lordship will kindly come to the power of attorney. But the power of attorney, my lord, of 15th of May 2010.
Same date.
Same date.
Yes.
Now, in this power of attorney, there are two persons who have been granted jointly.
Yes.
I'm sorry, my lord, there are four persons who have been granted jointly the power. Kunal Dalmia, Sunil Kumar Dalal, S. Prabhakaran, and Manish Khaitan.
Yes.
Now, my lord, in this power of attorney, page 24, internal page 3, to defend and or contest or prosecute litigation and or legal proceeding now pending or hereinafter be instituted concerning or relating to or arising out of the requisition and or acquisition proceeding and or realization of compensation on account and in respect of portions of the said property and for the said purpose to do all acts, deeds, matters and things as the said attorney or either of them shall think proper. Then, Lord, the next page, this power of attorney shall be irrevocable until and unless cancelled mutually by and between the appointer and the said Messrs. Lindsay Tower Private Limited in writing. Then, the Punalu reserves the right to cancel this power of attorney if any of the attorney acts beyond contrary to the spirit of this power of attorney. Right reserved. First, it says it is irrevocable.
Then right.
Then the right reserved. There is no right conferred, my lord, to the constituents, my lord, to realize any property, my lord. I'm not vesting any right to them. I'm always, my lord, saying that you are my agent in my name on my account. Then, my lord, the power of attorney, my lord, which was, my lord, revoked. That is at page 27. But this was, my lord, in 2010, and my lord, it was revoked on, my lord, November 2011.
Yes.
The reason for, my lord, the revocation is, my lord, another power of attorney was executed.
Yes.
Now, my lord, this particular power of attorney and the cancellation is not the subject matter of challenge before your lordships. Now, my lord, the reason given in the last paragraph is because of, my lord, the another power of attorney was executed on 21st November. That is, my lord, on the previous day. As on 21st, there was, my lord, the first power of attorney which was there in force.
No.
Lord, the first power of attorney with respect to four persons is dated 15th of May 2010.
That is there.
That is there.
Correct.
Now, my lord, the second power of attorney that was, my lord, executed is on 21st of November 2011.
So now here this is said, therefore the above power of attorney executed on 1510 is hereby cancelled. So that is cancelled.
That stands cancelled after, my lord, the second power of attorney was executed on 21st. This is dated 22nd.
Yes, on 22nd November, a new power of attorney was entered.
Lordship.
Separate power of attorney was entered.
Lordship. Twenty-first আগে পরেরটা করলো second power of attorney or 22nd cancellation. After
51 cancelled, 21 new was entered into.
Lordship. Lord, it is when Lord the new power of attorney was granted, Lord, the first power of attorney was in force.
Yes.
Because that is the point that I am trying to make out.
Because 21st you have entered a new.
New.
And the 15 was cancelled on 22nd.
The next day, the following day it was
yes,
cancelled.
Next day.
Yes.
So on 22nd, there were two power of attorney.
Lordship. On 21st, rather, there were two power of
Power of
attorneys.
attorney.
Lordship. Now, Lord, the other power of attorney at page 29, that is dated 21st of November 2011. Now, Lord, this is the subject matter of Lord the challenge and its cancellation. Now, Lord, here, Lord, the power was conferred upon two persons, the plaintiff number 2 and plaintiff number 3. Whereas plaintiff number 1 before your lordship in the suit is the company, and company has no cause. Company was never granted. So, Lord, the relief, if any at all, it is confined, Lord, only to the plaintiff number 2 and plaintiff number 3.
Correct.
Then, Lord, kindly come to the second paragraph of page 29.
Yes.
To sign and file application to appear, to plead, to argue, to act, to engage advocates and other consultants to move and file petitions in miscellaneous, original, review, revision, appeal, or other proceedings in connection with land acquisition matters pertaining to the premises situated at number 13 Lindsay Street, Kolkata 87, pending before the land acquisition authorities and respective appellate authorities, including appellate tribunal and all courts in India on behalf of Punalur Paper Mills Limited. Any such action of the said person shall be binding on us. We further agree to confirm and ratify all their acts done under this power. I hereby agree that all the act, deeds, and things lawfully done by the said attorney shall be construed as act, deed, things done by the company, and I undertake to ratify and confirm all and whatsoever that the said attorney shall lawfully do or cause to be done by virtue of the power hereby given. So, Lord, by this, all that was, Lord, granted was to conduct the litigation on behalf of Punalur.
With regard to the leakage.
Yes. With regard, before, Lord, the authorities, appellate authority and courts on behalf of Punalur Paper Mills. Punalur Paper Mills is a public limited company. Now, Lord, page 31 is, Lord, the deed of revocation. Now, Lord, the deed of revocation is dated, Lord, 11th of May 2021.
Yes.
Lord, the second paragraph. And whereas with the authority vested on me by a board of resolution passed on 12th day of April 2021, by the board of directors of Punalur Paper Mills Limited, it has become necessary and expedient to revoke the power. Now known all, and by this deed I cancel the said power of attorney and absolutely and completely revoke also all powers or authority thereby and thereunder either given to them, either expressly or impliedly, to all intent and purpose, provided that nothing herein contained shall render invalid or ineffective any act, deed, or things lawfully and bona fide done or caused to be done by the said attorney under and by virtue of the power given to him before the revocation of this presents. So, Lord, there are two things here.
So this is the document.
These are, Lord, the main documents. Lord, on this, Lord, the suit is rather founded, and all others are ancillary. Lord, that your lordship will find. But I'll one by one, Lord, I'll place before your lordship. I'm trying to cut short the matter, Lord. Now, Lord, this particular, Lord, the cancellation, Lord, it was, Lord, informed that your lordship will find at page 333, volume 3 of, Lord, the application. It was informed on 12th of July 2021. to my learned friend's client.
333.
333, volume 3.
You the volume 3.
Oh.
Uh-huh. Yes.
My lord, this is addressed to my lord, both of my lord the constituents. This is dated 12th of July 2021. This is to inform you that the power of attorney dated 21st day of November 2011 issued on behalf of Punalur Paper Mills Limited in favor of Mr. Kunal Dalmia, son of such and such, was already revoked by a revocation deed dated 11th May 2021. Since the power of attorney has been misused from your part, as you are aware, the revocation deed is already filed in the annexures filed in title suit number 614 of 2021 on the file of the learned City Civil Court, Kolkata. You are informed not to represent Punalur Paper Mills from the revocation date by engaging any advocate before any court. And Lord, this is not the purpose of Lord why he was appointed. So we've given him appropriate notice to say that you do not represent our company any longer.
Yes.
Lord, another important document, Lord, that I would like to show before your Lordship, Lord, is Lord, the extract of the minutes at page Lord, 209, volume 2. That is a meeting of Lord, the Board of Directors, dated Lord, 9th of May 2016.
Yes.
Now, Lord, this is Lord, the extract from the minutes Lord, of the meeting held on 19th October 2011.
Yes.
Pursuant to which Lord, that the 2011 power of attorney was executed in favor of Lord, this petition, plaintiff number 2 and 3. Here also your Lordship will find Lord, about Lord, 7th line. For and on behalf of, in the name of the company.
Yes.
To do anyone or all of the act, deeds and things either solely or jointly, that is to sign and file application, to appear, to plead, to argue, to act, to engage advocates or other consultant, to move and to file petition in miscellaneous original review, revision, appeal and other proceeding in connection with the land acquisition matters pertaining to premises situated at number 13 Lindsay Street, Kolkata, pending before the land acquisition authorities at Kolkata and respective appellate authorities, including appellate tribunal, all courts in India, on behalf of Punalur Paper Mills Limited. Therefore, Lord, the board also resolved, Lord, the nature of Lord, the power of attorney to be granted.
So this
not
is the...
coupled with any interest, Lord, in respect of the subject matter on which, Lord, the power was granted.
So this is the minutes of the meeting prior to the...
Yes, I am only referring because, Lord, to show that what was ratified by the board.
Okay.
And in pursuant to the ratification by the board, the power of attorney was, Lord, also executed in the similar terms. Now, Lord, here I take your Lordship, Lord. Your Lordship, in my Lord's order, when Lord dealing with Lord the GA3, has dealt with the entire facts, Lord. Those are there. But Lord, The other thing, Lord, I must point out before your Lordship, Lord, that the division bench, while dealing with, Lord, one of them, Lord, the orders passed in the trial court, that is, Lord, the city civil court, had, Lord, made certain remarks which were taken up, Lord, before the Supreme Court. The Supreme Court also modified those. But instead of, Lord, referring to, Lord, that portion, Lord, may I just draw my Lord's attention to my Lord's order dated, Lord, 5th of July 2023. Because that will be entirely, Lord, your Lordship has summarized it. Lord, I can hand over a copy.
Yes, it is there.
If it is
Here.
it's there. The Lordship has, Lord, dealt with the number of, Lord, the suits that are pending. Thereafter, Lord, allowed, Lord, the application, Lord, of my client, Lord, for stay. No. Oh, yeah. Division bench order. No, 800. Lord, your Lordship will kindly come to paragraph 10 at page 7.
Yes.
Now, Lord, that your Lordship has given a quotation of the division bench, Lord, the order dated 22nd September 2021. Page 9, about, Lord, the second paragraph.
Yes.
This clearly establishes that the cancellation of the power of attorney is prima facie illegal, as it is an agency coupled with interest. Why I am pointing out, because, Lord, this is the prima facie, Lord, the finding by the division bench.
Correct.
And, Lord, then I'll take your Lordship, Lord, to the Supreme Court.
Yes.
And, Lord, this being a prima facie finding, whether it is binding on your Lordship. Because, Lord, in course of an interlocutory proceeding, if a finding is arrived at by the court, Lord, that is not binding in the final stages of the hearing. But that is a tentative finding. That is an established law. Now, Lord, now I have shown before your Lordship that it is not an agency coupled with interest.
Correct.
Then look the last paragraph. The KHM had in the meantime realized a sum of 9 crores and odd on the basis of the order passed by the coordinate bench on 4th January such and such in F80 number such and such. It is undisputed that the power of attorney was revoked much later on 11th May 2021. And at that time, the KHM was entitled to the said amount. A suit filed subsequently cannot deny the payment of such compensation amount without Punalur establishing their right to receive the said compensation amount or on revocation of the power of attorney. However, the learned trial court did not permit the parties to utilize the compensation amount till the disposal of the suit. Then look the next page, second paragraph. Since we are of the prima facie view that the cancellation of the power of attorney was illegal and the documents executed in favor of KHM are establishing a clear right to receive the compensation. At this stage, we do not direct KHM to return the said sum of rupees 9 crores and not to Punalur. Now, Lord, Then again, your lordship will kindly, my lord, turn to page 11. That is the Supreme Court's order. Now, my lord, the last paragraph, page 11 of the Supreme Court quoted order, we clarify that the observations made in the impugned order are only for the purpose of disposal of the appeal before the High Court and would not be treated as binding and conclusive finding. By way of abundant caution, it was, my lord, written by the Supreme Court.
Yes.
So I am free to argue before your lordship
Yes.
that, my lord, the finding returned at the interlocutory stage is not binding on your lordship. Should I come on the next day?
Okay.
So, my lord, I'll just conclude my argument on the next day, my lord, only on the point, my lord, whether it is coupled with interest or not. Having read, my lord, the power of attorney.
Yes. Concession suffering for the plaintiff. Concession suffering for the defendant. Counsel for the defendant has argued at length in connection with J1 of 2024, but due to paucity of time, hearing could not be completed. Case adjourned. And date fix है क्या? नहीं. Not the matter appears. कम है, कुछ date नहीं है. 345 का.
Next week.
11th.
অনেক দিন পিছনে চলে যাবে
सब report
প্রায় 1 মাস
नॉन कमर्शियल है ना?
না না এটা নন
11th February at 3:45. 11th February
Lord.
3:45.
Lords, grateful.
May I have my lord kind leave, my lord, to mention one matter, item number 26. My lord, only, my lord, I'm request, my lord, to, my lord, instead of 17th, my lord, may it appear on 20th. I'll inform the other side. Lordship has said, my lord, returnable date is 17th of January. Instead of 17th, may it be 20th, my lord.
Huh? कौन सा item
26.
20?
26, my lord, which I joined virtually and did, my lord. I did not hear the date, my lord.
The commercial?
Yes.
26.
Yes, my lord. Lordship has kept it on possibly 17th, my lord. Instead of 17th, may it be 20th, my lord.
Rashmi Metal.
Yes, my lord.
Again, who is for the other?
My lord, I'll inform the other side, my lord. I could not contact him immediately. I'll inform him.
Time is fixed.
No, no, no.
Yeah, what is the date?
17th lordship had kept. Instead of 17th, may it be 20th, my lord.
20. February.
January 17th. Instead of January 17th, January 20.
20 January.
Grateful, my lord.
Item number 24, my lord was pleased to pass it over. Lord, may I only pray for one indulgence, my lord?
Of the commercial?
Not commercial.
Non-commercial.
Item
Yes.
24, my lord. Lord, may I only pray for one indulgence, my lord, since Tuesday, my lord, I may not be here Tuesday or Wednesday. My lord, may I only pray if it can be, my lord, taken up on Monday anytime.
It will come on Monday. It will come on Monday.
Would it be your lordship's pleasure, my lord, too? Because it's a section 10 filed by my the other side, my lord. We are the plaintiffs in the matter.
There is not much matter in the commercial division.
Lordship, will come.
It will come. It
will be there.
My lord, may I be permitted to mention a matter? My lord, this is a commercial suit. We have filed an application seeking direction upon the department to accept the written statement which is being filed beyond 30 days, my lord. The matter was supposed to come up on the list today, however.
And it's not filed.
My lord, we have not been able to file it. We have filed an application so that the written statement may be accepted.
That is the. Where are you persons are living? Every day this court is cautioning all the advocates in the commercial division. If you want to file the written statement, please take the leave and file in the department. If you will not file in the department, within 120 days, the court
My lord, we are
hands
within,
are the tight.
my lord, we are within 120 days.
When
beyond
you
30
receive the
days.
writ of summons?
4th of October, your lordship.
4th of October. So when the 120 days is going to be over?
On 28th, your lordship, or this end of this month.
January.
Huh?
And for the plaintiff.
Come on Monday with the written statement. I will pass an
My lord.
order to file in the
My
department.
lord, grateful, my lord.
My lord, may be permitted.
Huh?
Item number 44, written action can this time be taken.
Let it be. Come on Monday. We'll see to that.
Deeply.